I open this hearing of the Parliamentary Joint Committee on Law Enforcement into the capabilities of law enforcement to respond to money laundering and financial crime. I begin by acknowledging the traditional custodians of the land in which we meet and pay my respects to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islanders peoples here today. The committee will be conducting today's hearing via video conference and in person. There are public proceedings being video streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It's unlawful for anyone to threaten or disadvantage a witness on the account of evidence given to a committee, and such action may be treated by the Parliament as contempt. It is also contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. If a witness objects to answering a question, they should state the ground upon which the objection is being made, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. Can't separate the papers. Committee determines to insist, as the committee determines to insist on an answer, a witness may request that the answers be given in camera. I remind parliamentarians of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. I remind witnesses who are appearing via video conference and who are not speaking to mute their microphones. Before I welcome the Police Federation of Australia, I just want to acknowledge that Senator Antic is on the line, and Mr O'Brien, if you could just identify yourselves.
Thank you, Chair. Alex here.
Thank you, Senator.
Yep, thanks, Chair. Lou here.
Thank you, Deputy Chair. I now welcome representatives from the Police Federation of Australia, and I understand that information on parliamentary privilege and the protection of witnesses giving evidence to the parliamentary committees has been provided to you. For the Hansard record, could you please state your full name and capacity in which you appear today? Good morning.
Good morning, Chair. Good morning, Committee. Thank you very much. Scott Webber, the CEO of the Police Federation of Australia, representing over 65,000 police officers across the country.
I invite you now to make an opening statement or to make some comments, Mr Webber.
Yeah, thank you, Chair. I obviously rely on our submissions, and we've been doing submissions in regards to this for the last 15 years. It's critically important to all police officers across all jurisdictions that unexplained wealth, money laundering, organised crime is targeted because it links into so many other facets of our work. And this is where your committee has done numerous times before the harmonisation of laws and started to progress forward. Like the National Crime Intelligence System, that's something that we fully support. We want to expand on. I think back in 2021, we had ongoing conversations about money laundering, counter-terrorism, finance, and including other professions like lawyers, accountants, financial advisors, liquidators, offshore service providers, real estate agents, to have be regulated and under the same scrutiny as financial institutions. I probably do have to clarify, Chair, that policing is in a very difficult stage of its progression in Australia, where recruitment and retention is our most critical issue. Across the board, we're at least 8,000 to 9,000 officers down. We have, states struggling to function. We have, very difficult to, task police officers to go out and deal with the truck and deal with the day-to-day calls. And that's so difficult for us not to be preventative as well, because we want to go out there and stop the crimes before they start. And this is, some of the conversations that we're having here today and your committee's been focusing on the last couple of years. But it's extremely it's extremely hard when we're just doing reactive jobs, and we're struggling to do that. And another concern for us, and it always touches in regards to organised crime, is money laundering, is illicit tobacco, and also the ATM abuse. Look, we've suggested many times before, the utilisation of AUSTRAC, and I know that's it's starting to progress further. But with the NCIS and using AUSTRAC and targeting, where those key points are, and then also looking at illicit tobacco, which is a massive issue. And I've said this many times to your committee and to our members and to our media, and also the illicit tobacco commissioner. If you asked me 5 years ago if tobacco was going to be a major crime issue and causation factor in our community, I would have laughed, but now it is. So with this committee, we look forward to working with you, developing policies that are preventative and assist police in doing their job. Thank you, Chair.
Thank you, and it's always good to have you come before this committee. And I've been on this committee for some time, and I think we have seen greater alignment between state and federal police, which is fantastic, but it's all about collaboration. And I think in terms of this policy going forward, we've had witnesses from various universities. We need that collaboration in relation to research, to also train up and skill up future officers going forward, because this crime is getting more and more complicated. So again, welcome. If I could then just introduce Senator Antic is on the phone, and Mr O'Brien, the Deputy Chair, and we have Mr Dan Rapicoli here today in person with me. So I'll just kick off with a couple of questions, if I could. Understanding that this is all about whether or not we have the capabilities to deal with this crime. What are the issues, and do you have any solutions around retention in the first place of officers to keep them in law enforcement? And what do we need to do then to recruit? I do just say that yesterday, hearing the universities and their approach and the degrees that you can get now, that looks promising, but they're not necessarily people who are going to go into our police forces. So have you got any solutions of how we can attract and then retain officers?
Yes, Chair. Look, we've had ongoing summits and conversations, and we spoke to both sides of government before the last election, and the Police Federation of Australia has three priorities. Look, we'd like to salary sacrifice our mortgages to retain but also attract. It's difficult in regional areas or city areas for police officers to live where they work. And if they're not living where they're working and they're commuting, 2-3 hours to work, when there is a critical issue, a critical incident, whether it's a tempest storm, flood, or there's a siege, or there's an active armed offender, we want those police officers to be readily there. But we're finding that it's difficult for the police officer to get there because of transport and that tyranny of distance. So and everything we're asking for already there is pre-existing legislation for. So this is not a wish list that's high in the sky. It is actually something that is already obtainable by people in health. We have our police officer members that are married to ambulance officers. They already get to salary sacrifice $17,000 of their mortgage, and I think that would go a long way to attract and retain police officers. The next part of that is a blue card, similar to the white and gold card, and we've been talking about it for a long period of time. It's critical when police officers get injured on the job, whether it be psychological or physical, which occurs. We're definitely in a contact sport, and all the research shows access to medical treatment straight away and rehabilitation will get us back out there on the truck, keeping the community safe. It boggles my mind when we see professional athletes, they go out on the field, on the pitch, they get their arm ripped out of their socket, and then they're playing that next week. But we have a police officer that's tackled by an offender. They don't get treatment in the next 3 or 4 days, and they're off for a month. I think a blue card or assistance to health priority for police officers is critically important. And the last thing too is retirement with dignity, but also making sure that police officers, when they get to a certain age, they don't have to keep going out there and working the truck on a Friday, Saturday night. Look, I'm getting on in age. I know I don't recover well if I go out on the footy pitch or even run around with the kids. But I know if I was working Friday, Saturday night on the truck and I'm wrestling with an 18, 20-year-old offender, which occurs every single Friday, Saturday night across all our capital cities and every single day, I know I'm not going to recover the same way. So what we're saying is when you have an adequate super fund, when there's adequate let's retire with dignity, so that police officer is not constantly on the books in regards to accessing his sick leave or workers' comp, and it takes away that burden not only from the Medicare system but also from the states as well. The second part of your question, where we could, what sort of strategies could we look at in regards to money laundering and dealing with organised crime? I think we're sensible policy based and that harmonised approach, and that's where the Commonwealth Youth Committee can really deliver. And the example that sticks out to me the most is illicit tobacco, because we do not have a coordinated approach. It's extremely difficult for police officers in the state, not only that we don't have the adequate training for myself as a police officer on the beat, walking down the street, what do I do, but also the regulatory schemes around it. We should be instantly giving a fine to the person that's selling, a fine to the business, the landlord or landholder, and the onus of proof should be reversed. Then on top of that too, there should be a joint task force with the ATO, obviously with cross-border, the illicit tobacco commissioner, and all different states where we can actually go in there and confiscate. And Chair, a big problem for us too is once we confiscate it, it costs our local police stations, our local area commands, our local police so much money to store that, and they do not have that funds. And on top of that too, disposal of vapes is extremely difficult, and of any tobacco product. So we'd like a coordinated approach with that too from the Commonwealth.
Okay. In your submission, you argue for a nationally harmonised, unexplained wealth regime to provide law enforcement agencies across the country with an effective mechanism, information sharing and collaborative investigations and task force, which you've alluded to just then. What issues are the members experiencing in investigating unexplained wealth matters that a nationally harmonised regime would address? Can you give us an example of that?
Well, a prime example, we see outlaw motorcycle gangs. The borders mean nothing to them. They just utilise the legislation. A prime example in the ACT, there was hardly any outlaw motorcycle gangs 5-6 years ago, and now every single chapter has a clubhouse there. They utilise the legislations of the states or territories to their advantage, whether that be dealing with the proceeds of crime, setting up the bases of operation, utilising youth, or just manipulating the transport systems as well. With a harmonised approach, especially in regards to unexplained wealth, it should do one stop and we could freeze all assets straight away. And then on top of that too, there should be a high qualification where, if that state or territory takes a large sum of money and puts it back into the coffers of the Commonwealth or even the state, it should be distributed evenly where it's going back to actually prevent crime. Such as we see so much with the pocket funding as well. We really want that to be extended because sometimes we get the conversation that the cupboard's bare. There's no allocations in regards to pocket funding or unexplained wealth, but we know every single day that we're actually collecting that, stopping people actually taking that money overseas. But in regards to the harmonisation of the legislation, it would just mean it's a one-stop shop, that you don't have to deal with different laws. Straight away you seize and confiscate and freeze assets across the board and utilise powerful Commonwealth legislation to actually investigate and seize those assets.
Thank you for that. I'll just ask one more question and then I'll go to my colleagues. But what was raised by witnesses yesterday was in relation to, yes, and you spoke about it's great, we now got accountants and lawyers part of this second trench, but there's still a gap has been expressed in relation to luxury goods, whether that's cars, whether it's watches, whether it's art, whether it is in fact, and we had one person raise, and that is in relation to livestock. And with all the changes that are happening now, would you like to see it go further and incorporate luxury goods as well?
Yeah, look, I totally agree with that. We've seen the retail theft, and you just need to speak to organisations like Aura that actually keep a stockpile of all those thefts. There are systems already existing. Police are starting to utilise it, but again, it needs to be backed up by legislation from the Commonwealth, and on top of that, linked into the NCIS system, where we can actually access it across the board. Exchange of information and communication is critically important, but also the policies backing behind it. In most of the larger jurisdictions, there's rural crime officers, and they deal with livestock theft, which is a huge issue as well. I have to admit, I do not have heard of organised crime utilising that, but they would definitely do that because there's a lot of money there. But in saying that, Chair, if you asked me, organised crime was prolific in tobacco 5 years ago, I would have said no too, but now they are. They are the main key with it. But luxury goods definitely the same way. And that's what we're seeing too, one of the drivers in youth crime and also home invasions is they are targeting that high-end luxury vehicles, luxury goods, even art, and it's purpose-built theft or home invasions to actually obtain those certain items as well. Chair, those ideas are well welcomed by the Police Federation of Australia. Anything that gives us an extra arsenal in our belt to deal with crime, we welcome.
Thank you for that. Mr Rapicoli, would you have some questions?
Yes, cheers, thank you. Thank you for being here as well, and thank you for giving us a very detailed report. This has been issues for decades and decades, and we don't seem to be getting on top of it. Where is the failure there? What can we do more as a government to be able to actually get on top of it? And opposition as well, us in this whole place. What can we actually do to make a lasting difference here that will make a difference out on the street?
Thank you for that. Yes, and as I highlighted before, we've been talking about this for decades. Everything that we've suggested, the harmonisation of laws, I think that needed to be done yesterday, changing of policies and the way we focus in regards to different crime categories, whether it be illicit tobacco, money laundering. It is about that exchange of information and making sure that it is readily available to the police officer out on the street, because they are the eyes and ears, and they're the people that are speaking to community. It's too late once they've established a business and they've been doing it for 5 or 6 years, because they're constantly having updates, changing their protocols, locking in new encryptions, and they have more money, more assets, and more knowledge and history how to get away with it. So look, let's hit them where it hurts. Unexplained wealth. Harmonise that, take away all the proceeds of crime, reverse the onus in regards to all these offences where they actually have to prove that it's not ill-gotten, that it's not illicit tobacco, that it's not an illicit substance. I think that's critically important. And then the next thing, which is a long-term one, is making sure that we protect the protectors. That is, retaining our skilled police officers. Police officers are leaving, our attrition rates are extremely high. We have this problem, and so does New Zealand as well, where we are losing skilled officers. So we need to have those retention mechanisms, salary sacrificing a mortgage, blue card, access to, our super retirement with dignity. So then, therefore, those police officers can go out there and recruit. Our biggest problem at the moment is police officers on the ground like me are talking to their family and friends and going, don't join the job. Morale's at the lowest I've ever seen it. Do something else. And that's really hurting us as well.
No worries, thank you. Go to the other two if you want. I have more if you want.
Yes.
I don't want to ask any.
Yeah, no, it's fine. You go, and then I'll go after you. It's all good.
Thank you. So with the retention of the police officers, right? it's a really thankless job that you guys do, and thank you for what you and all of the crews do around the country, because it's extremely important and you don't get a lot of praise or thank you for that. What, besides the super things, a few other things, how do we make the job more enticing and to incentivise more people to come in from university, from wherever, if they finish in a trade or want to come in with some different life skills as well, to actually make a difference, when all we seem to do is see on the media and that you guys are doing the wrong things. They don't see the good positive changes that you all make. How do we get that better, and how do we make more of a difference in that space?
Oh, look, yes. 99% of the work we do is actually extremely beneficial, and is actually keeping the community safe. Occasionally there's bad stories about us, but they sell more papers. Sorry, they sell more likes. And that's a huge issue for us. Look, I think COVID really damaged our brand. We were the public face of COVID, not by choice, but by direction, and we enforced the rules of the governments, and we willingly do that too. But in saying that, I think we need to go back into the schools. There needs to be, that education base. The $1.7 billion in regards to recruitment for defence. A recruitment fund for policing would be fantastic as well. But we're competing with a lot of other industries. Policing is a great job, but at the present moment, you aren't going out there locking up crooks. We're going, some police stations and some officers, their entire shift is virtually dealing with domestic violence, which again needs to be dealt with. But we need to change legislation in place where we're not reactive, we need to be preventive, and there's heaps of mechanisms in place. The other thing that I think we need is to utilise technology, where our evidence in chief should be video like this. Our conversation, where I don't, let's just say this conversation was going to a criminal court. I'd have to type out every single word. I'd have to get a statement of every single, senator, minister, member, and also then I'd have to put that together in a brief. Why wouldn't this solely be the evidence in chief? Why can't the judiciary just take that? And that's one of my biggest gripes, is that police officers are there and we deal with the community's frustration, we deal with the media angst, and we lock up the same offenders and then they're released on bail. And then the next day, I lock up the same offender and they're released on bail. Look, we're not saying that every person needs to go to jail, but if someone's on remand or, like refuse bail and they breach again, they need to go into custody because they've breached society's laws. They don't obey society's rules. Therefore, they should not have the right to be in society as well.
Thank you. Thank you, Chair.
Well, thank you. I just wanted to go and just touch on the issues that we're dealing with are global. There's no borders anymore. Money laundering, organised crime, it's international. There's some great collaboration with other countries. But there was evidence yesterday, just a concern when you've got the police force that you have, we've got law enforcement, that we tend to focus on those organisations that have a presence in Australia when we know there's money being laundered coming in from international. I mean, you can still only do what you can do with the amount of people that you have available. Do we need to see a recruitment drive and expand our police forces, and particularly in terms of when it comes to these sort of crimes, whether it's organised crime, drug trafficking, whether it's money laundering, child exploitation. I mean, there's so many areas. If I say today we've got to focus on money laundering, those officers will have to come from somewhere else. So is it a fact that we need to invest not only in general recruitment and retention, but we actually need a drive to get good people coming in, working in law enforcement?
I totally agree, Chair. Look, we've always had a boom and bust mentality to recruitment, and usually just comes in a cycle. But it should be, on population base. And most jurisdictions around the country, actually have gone backwards, and they have less police officers than they did 20, 30 years ago. But on top of that too, police officers are doing so much more with less. And then those international boundaries. I mean, when we're talking about money laundering and cybercrime, most of the people that we're dealing with, we can't chase them because they go back to a sovereign state that we actually have no presence in or not allowed to investigate in. That makes it extremely difficult in saying that. So then we need to do the preventative measures, make sure there's appropriate security firewalls and protections of people, education and awareness. But on top of that too, yes, we do need more specialised police and targeting, whether that be recruiting straight from university or you get extra credits, or there's numerous other facets or incentives which some of the jurisdictions have done now, like a $20,000 incentive to come and join. But that's the difficult is the nature of policing too. You can't work from home. Maybe someone who's accessing intel, but or money laundering, but most police officers can't work at home. We work Friday, Saturday nights. We work Christmas Day. We work really unsocial hours. So in regards to family friendly and mental health and well-being, it's extremely difficult to highlight those facets of the job, regardless of the extremely rewarding, regardless that you're keeping the community safe. There is a toll that's taken on police officers. But there are so many different initiatives that we can do, but I think we need to come back down to the bread and butter of actually boosting our numbers here straight away, streamlining, harmonising laws and making it a lot easier for police officers to give evidence forward as well.
We also understand how crime is changing, with technology, AI. From your knowledge, do we have the capacity with law enforcement? Are we keeping up with technology? Are we training and skilling up the officers to deal with that technology and AI, for instance?
No, look, I think we're falling behind. There's obviously, people that are funded from, different sovereign states. They're very, technically savvy. They have unlimited funds and they're attacking us left, right and centre. Obviously, we rely on businesses and governments for that adequate protection. But is there enough people out there? We're only back capturing. There's not that level of prevention that needs to be done. We really want to be proactive and stop the threat before it comes. Stop the email, stop the cyber hack, stop the money laundering before it actually occurs, or pick it up straight away. That's not occurring because, as you highlighted, Chair, we just don't have the capability or the numbers.
Can I then ask, in terms of capabilities and having that expertise, would the Federation, have you got concerns with law enforcement having partnerships in private enterprise that are dealing in this space? Have you got an issue with those sort of partnerships and arrangements to give us more capacity?
Look, from the Police Federation point of view, we always look at this on merit. And again, there'd have to be appropriate checks and balances. And again, they'd have to, be scrutinised. But, police are embedded in numerous other industries, and the police, and we deal with different people every single day. The police forces around the country, their entire workplaces all of Australia, and their job can range from, helping someone get the mail to the most horrendous offences that occurred in our community. Look, I welcome partnerships, especially if there's specialised knowledge. We have done that before. And again, to probably, at the present moment, to, supersede what's occurring across our community and the globe, we do need to have those partnerships where we look at it from a different point of view. We've done it with education and training police officers. We've done it with our training, and we do it with specialised people in certain crimes. But yes, you asked me this question 5 years ago, I probably would have said no, but now, because we are at that critical point where recruitment and retention is such an issue and we are so low on numbers, yes, we welcome partnerships.
Thank you for that. My final question in relation to the National Cooperative Scheme and unexplained wealth. There's been a number of jurisdictions that have said no to participating in that for various reasons. Their existing state legislation is stronger and more effective. The scheme would not provide any net benefit for existing opportunities for joint operations. The sharing of arrangements would be burdensome on state police, and that there's no guarantee of that relationship, flowing two ways. So how would you suggest we can convince the jurisdictions that harmonising is really the only approach to be able to deal with these types of crime?
Well, look, I just think the rules around them have to be extremely clear. Look, we're having these ongoing conversations about the National Firearm Registry. Every state has their own set of rules, and every state probably thinks their practices are best. Again, it's through the police ministers, I think, and the commissioners, and when they sit there and have their council, they ongoing have these conversations about unexplained wealth. But it needs to be clear that the unexplained wealth, and it will come back to the cash. It'll stays in that state and is beneficial in regards to that state seizing it. There needs to be fair breakup. And it goes to the same argument, whether it be GST or the National Firearm Registry. People want ownership of that money. People want ownership of that intellectual property. We just need to highlight that ownership, that intellectual property does remain with the state, and the Commonwealth is there as a storage of all the information and data and a coordinator of best practice. So the Commonwealth's not instead of, as well as.
Yeah, well, I think the National Firearms Register, that was implemented in the last term of government, which was great, but I hope we don't wait 30 years to actually have that harmonisation and move forward on these sorts of crimes, because, 30 years on before we made it, and we still haven't seen that finalised. And the states were so different in terms of what they had achieved around firearm registration. So I don't think there are any further questions. It's always informative to have you come before the committee. We really do appreciate your submission and the time you spent with us this morning. Thank you.
Thank you, Chair. Thank you, committee.
Thank you.
Might be a bit weird, really, but anyway. Right, video link, we're here. Ready? Great. I now welcome officials from the Commonwealth Director of Public Prosecutions. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to parliamentary committees has been provided to you. For the Hansard record, could you each please state your full name and capacity in which you appear today? And then I'll invite you if you want to make some opening comments. You're on mute, I think. Can you hear us? Should be right now. Just each state your full name and capacity in which you're appearing today. Thank you. Don't seem to be able to hear you.
Can you hear us now, Chair?
Yes, yes, that's great, thanks. That's
All right,
better.
I'll try for the third time. Let's see how we go. Thank you, Chair. So Andrew Doyle, with the Commonwealth Director of Public Prosecutions. I'm an acting national practice leader. I'm responsible for the Fraud and Specialist Agencies Practice Group.
And thank you, Chair. David Barlin is my name. I am the National Practice Leader of the Serious Financial and Corporate Crime Practice Group. And in my role, I oversee most of the serious financial crimes that the DPP prosecutes.
Welcome to you both. Mr Rapicoli is here in person with me today in Canberra, and we have Senator Antic and Mr O'Brien, the Deputy Chair, online. So do you have any opening comments?
We don't have an opening statement, Chair. We're happy to answer any questions and assist you in any way we can.
Great. Thank you very much. Mr Rapicoli, would you like to start with some questions?
Thank you, Chair, and thank you for joining us, Andrew and David. Your submission highlighted the resourcing burden that you have within the department. What are your total staffing numbers currently?
We sit at approximately, is it 400 to 500 staff?
Yeah, it's in between. I think it's about 425, 430. We can get you an exact total, Senator, if you need that, but the total number of staff, I think, in the office sits at about 430 or thereabouts. That's made up of both legal staff and corporate staff. And the corporate staff obviously assist the legal practice in carrying out their various functions.
And is that enough staff for the work you guys are doing?
Well, I think the answer to that Senator, is I'll put it this way, is that the staffing is obviously a function of the budget that's allocated to our office, and we look to utilise the budget in the most efficient way, and we allocate resources to areas that need those resources. And I think, like most agencies will say, that they could always do with extra staff, but certainly doing the work we have at the moment, we have enough lawyers to deal with the matters that are on hand. Those budgeting and staffing requirements really, as other agencies have, we make do with the staff that we have.
That was a very political answer, thank you.
Was it?
So now, if we're cutting everything out of this, right, where we're not giving political answers, which is good, and we can do that in these committees, realistically, how many more staff do you need to be able to do what you're doing in a very positive manner, to be able to make a difference in this space where we can actually see these prosecutions happen quicker and in a more timely manner than what they currently are?
I'm not sure, and I appreciate the invitation, to be frank, and we'll take the politics out of it. I'm not sure really the answer though is we need X number of staff. Really, it's really a matter of finding the right people, and that's not to put some spin on it. It really is finding the right people with the right qualifications, there's a leeway in terms of our office, or a feed-in time to when new lawyers join our office to come across. To get across the complexities of the work and to have the experience to make decisions and work efficiently. So it's more about attracting the right person and having them hit the ground running. And at that point, we're getting real value for money.
See, that's a much better answer. I like that. How along the way are you attracting the right people then, and headhunting the right people to come and work in this department when they could be making a hell of a lot more money, I would imagine, outside in the private sphere?
Well, I think, Senator, probably one of the biggest attractions in terms is the actual content of the work that we do. So, and when we tend to retain staff that are very morally and ethically aligned with the public service and the prosecution work that we do. So the work content, we also have a fairly significant in-house induction and development building capability regime. So it's not unusual for newly minted lawyers, for want of a better phrase, to come here to learn core skills, and they may progress on and become barristers. Still resources available to the Commonwealth Director of Public Prosecutions. We may brief them for trial work and that type of thing, but it's we consider ourselves to be very good at establishing those foundational skills in training and development.
With the training and development that you're doing there, how many of them do stay on with you guys and don't go into other areas? Do a lot of them stay on board?
Well, I've been here almost 20 years, Senator, so I'm one of those ones that has certainly stayed. Look, we did go through a period of time where we had fairly significant attrition rates. We have a range of people that may come, and I suppose with the generational change, that tends to be people coming in for shorter periods of time, but we still have some lawyers in particular that will, we've retained for quite a significant period. Returning to the work that we do, you often find that prosecutors are very committed to the role, and they do tend to stay for a longer periods of time for that reason.
I would agree with that. And, there is a pathway in terms of, as my colleague has mentioned, either going to the bar and becoming counsel or indeed, in other agencies. And a lot of the people that work in our office are attracted to the range of work that we do with different agencies. Yes, we deal with the AFP a lot and state police, but we also deal with the ATO, ASIC, ACCC. And that interests people who are interested in a range of Commonwealth regulatory work.
But you did mention something that's quite critical there, and that is obviously remuneration. Recently, we have had the benefit of a prosecutor's allowance. We're in the process of negotiating that to be extended. That is quite critical for us and our workforce that continue. But obviously, we're working towards ensuring that occurs.
And what is the rough difference between where you guys are and where the private sector is roughly in pay terms?
It's a difficult question to answer, Senator, because it's quite a unique profession in terms of the prosecutorial work that we do. I think previously, prior to the prosecutor's allowance, there was discussion of, 20 to 30 grand at different levels less. That's been rectified in more recent times. There's obviously state directors of public prosecutions that prosecute state crime predominantly, whereas we prosecute federal crime. You've got a range of legal professions and regulators across the APS that have similar roles, and then you've got private practice with civil litigation, which I think the remuneration in those firms would probably be significantly higher than what we are as public servants. But I just return to the purpose and the work that we do, which we consider to be very important.
Good stuff.
Can I just have one follow-up question in relation to training and attracting? Do you liaise with universities in terms of the type of people and the work that you do to have some say in the curriculum that is being pursued through universities so that you've got, a bigger pool of people to appeal to?
We certainly attend career fairs at universities and get our profile out there in that way. We're not necessarily engaging with universities in terms of setting curriculums and courses, albeit we have and currently do have people on our staff that lecture at universities around the country. So they certainly, particularly in Commonwealth crime, we consider to have a level of expertise in that area, and so they're lecturing and educating students, university students in that space.
Thanks, Dan.
Cheers, thank you, Chair. How long does a typical case take from preparing it to actually prosecuting it? What's the average time frame?
The answer to that, Senator, is it depends what crime type as well, and that's not a lawyer's answer. It really does, because obviously you might have, what I would call a straightforward type fraud, where someone puts in some sort of false statements in a government department and they might receive a benefit, and that might be a fairly simple type of matter in terms of the evidence and the complexities of the offences, and that a government department might investigate that over a course of 2 or 3 or 4 months, and it might come to our office and that might be in court in a month's time. It really depends on the type of matter. Of course, we have a brief assessment practice and arrest practice, and I think it's just important to understand that. Obviously, if the police go out and arrest someone, that matter is in court at the point of the arrest. The criminal prosecution has commenced. In terms of a brief assessment practice, which I suspect is probably where your question is going, that really depends on the length of the length of the investigation, the complexity of the brief, and the size. Again, just to be very frank with you, some of the matters that we get referred by big regulators, ASIC, ACCC, the ATO, they're quite complex, lengthy investigations that result quite in a voluminous brief. And that does require some time for us to get through. And the answer to your question is that could take, from go to woe, start of investigation to the end of a prosecution, that could take a number of years is the answer. But I include in that various court appearances, appeals, things like that.
Yeah, it's a good point to make. I think, once we're in the criminal justice system, and by that I mean an arrest matter that goes through potentially committal into a trial in a higher jurisdiction, there's a number of factors that can contribute to the time taken and what would be considered delay. Obviously, defence can take a number of different issues. You're relying upon the court in terms of listing times. There are criminal procedure rules setting out timeframes for various mentions and that type of thing. But we don't necessarily control the time that it takes for a matter to proceed through the criminal justice system.
Okay.
We like to be prepared, and we certainly don't like any delay to be attributable to us. It does happen on occasions, but we expect once we're in the criminal justice system to be prepared to run that matter when the court requires us to do so.
And how do you go with having continuity with the team that are on those cases, especially ones that take that little bit long, that like large differences in times? Yep. How do you go with continuity?
That's difficult, again, is the frank answer, because to use the example that I gave, say there was a quite a large ASIC referral with a number of, let's just say, for example, hypothetically, a number of directors, for example, involved in different companies and company structures, and you're looking at some sort of corporations type offences, you might have one or two lawyers who have worked on that matter for a year or two, and it's either natural attrition or perhaps they move on to another area or perhaps they decide to leave the career for whatever reason. But for whatever reason, those people move on. That is then, we try not to reinvent the wheel. And so we have a team-based approach, and we try and have, for want of a better phrase, backup lawyers on matters, and we try and involve as many people as we can on those big matters to ensure that continuity. But it's not always possible, and we're at the whims of sort of staffing, issues as like any other agency. But we're aware of it, and we try and succession plan, and we try and bring in teams to avoid that. But sometimes it's inevitable.
All right, thank you. And my final question before we go back to the chair is, how do you go with staff going from your department to other departments and things like that? Do you have many that move around a lot in the space here where you're losing them to other government groups?
Two aspects to that. One, we do have people that actually leave our office to join other agencies, but we also have, some secondment arrangements where people, they're technically leaving, but they come back and they're still attached to our agencies. And in terms of the first, people leaving, we've found, even though it's disappointing that some good people leave, that's still a benefit to us, because even if one of our really good lawyers leaves to go join ASIC, for example, or the ATO or the AFP in terms of their legal, we have that relationship. They understand how we work, and we can leverage off that to our benefit. And similar with secondments, we've found secondments really beneficial, because from the partner's point of view, the lawyer comes back and they understand intimately how the partner works and some of the the internal machinations, the internal decision makings of partners that's not always apparent to us. So that's not really an issue for us, and in many respects it can be a benefit for us.
Good stuff. Thank you very much.
Thank you. I just want to touch on AI and technology, how that's changing in terms of organised crime, money laundering. The bad guys seem to always be ahead and obviously have a lot more money at their disposal. What sort of challenges do you see going forward in this area in relation to the use of AI and just general technology?
Yeah, I think one of the biggest challenges when it comes to the use of AI in committing the criminality will be attribution or identity of the individual behind the AI and attributing responsibility. So in situations where, for example, you might have deep fakes or, fake voices or images being used for identity purposes, it creates real challenges, particularly for investigators, to identify who is really behind that. So there's some really significant challenges there. There's obviously a need across the APS, law enforcement and the DPP included, for a capability uplift in terms of artificial intelligence and utilising AI to become more efficient. We're obviously certainly aware of the recently released AI plan and taking steps internally within the DPP to engage with AI to really leverage off some of those capabilities to make our work more efficient. But when it comes to the criminals, they tend to have endless resources, and it's certainly a challenge keeping up with the different types of criminality that's being committed. but we are quite reliant upon investigators and law enforcement to investigate those matters and then prepare the brief, which is then submitted to us for the purposes of the prosecution.
You say in your submission that existing money laundering and financial crime offences are appropriate, but the 2021 reforms were yet to be substantially tested. So have there been any listed for trial thus far? And has there, your assessment been as to whether there's any demonstrated issues or gaps in these reforms?
If you're referring, Senator, to, for example, some of the changes that were made in relation to offences and the additional offences in relation to, proceeds of general crime, there have been some prosecutions in relation to that. There's been some pleas of guilty, for example, and there is a couple of matters still going through the courts. When we say it really hasn't been tested, it hasn't been tested in the sense of there's been no appellate review, no question, and has gone to the appellate courts in relation to, either the elements of those offences or the evidence required or anything like that. So in that respect, it hasn't been tested, but it's certainly been used, and law enforcement agencies has been certainly looking to use those offences. And those offences do cover a bit of a gap, I think, which was one of the reasons that was brought in, where we, in terms of classic money laundering type offences, you have to prove the money is either directly or indirectly related to the proceeds of crime, and you need to, without getting into the sort of the legal technicalities of it, you need what we would call a predicate offence. You have to tie it to a certain type of offending, is perhaps a way to put it. The proceeds of general crime allows investigators to really look at things like unexplained wealth, things like, where we don't know what the crime was, but we know the money came from somewhere. So that has been useful. And our submission talks about the fact that given the range of money laundering offences now, and indeed other fraud offences, we don't see any major gaps in the offences. It really just does depend on the evidence and what the police investigate, or indeed other agencies, and how we choose to put cases about what offence is best fit to capture the criminality.
We had evidence yesterday in relation to and comments around sharing of information, and the fact is that you might be given information about X and Y, but you can't use that to prosecute. Is there any way that we can actually look at overcoming those? Is that just because of legislation differences in each state and different agencies? It just seems like it's a catch-22. You've got the information, you know what's happening, but you actually, say in Victoria, can't then use that information to prosecute.
Well, Senator Chair, there's for the purpose of a prosecution, the investigative powers that are being utilised are quite invasive, whether it's a search warrant, telephone intercept powers, and so it's balancing the right to privacy versus the power of the law enforcement that they're executing for a particular purpose. And there's real risks for a prosecution if the power is used for a particular purpose and then that information is then shared outside of that purpose. So we're always very conscious of when a brief comes to us and evidence has been gathered, what was the power that was utilised, and can it be used for the purpose of the prosecution? So if you're looking at information sharing more broadly, it's I suppose a matter of considering whether or not that information is worth sharing, despite those privacy sort of principles, because there's concern about really serious criminal conduct. And there are some exceptions in the legislation that talk about, if it's criminal conduct, suspected fraud, then that information can be shared for those then extended purposes and potentially used in criminal prosecutions. But it would be a matter of looking at each of those powers that are being exercised and working out whether or not it should be shared, because in effect, criminality is occurring.
Can I just add to that, Chair, just briefly? I echo my colleague's comments, but I suppose that you need to look at where that information is going to end up and what it's going to be used for. So in terms of, if you're looking at purely intelligence, intelligence from a law enforcement agencies, then, in terms of their sharing capabilities, they might be able to share information to create intelligence to support their investigation or indeed start an investigation. Whether that intelligence translates to admissible evidence is a different aspect. And so the sharing, there's two parts to it. Can law enforcement share for the purposes of intelligence? Probably they can. That's a matter for the agencies with their own powers. But then how is that information then, how does that filter through to us to be admissible? And in relation to what my colleague was referring to, at that point, the admissibility will depend on how the information came to be, what powers were used and things like that. There's two parts to it, if you like.
When it comes to the second trench of reforms that's going to come into effect, have you been involved with any discussions, in terms of the accountants and lawyers? There's obviously, the majority of them are probably going to welcome it. There's going to be some that will struggle with the change in terms of being able to be across it. Have you been involved in any discussions around advertising so that the general public know? I mean, that was an issue for the Real Estate Institute in ensuring that the questions that they will now be responsible to ask a seller and a buyer are somewhat invasive compared to what's expected of them now. So does there need to be a public awareness campaign?
I think information, it is important for all those practitioners who are going to be subject to that second tranche to be aware of it. In relation to your question about our involvement in relation to law reform and similar issues is really through AGD, the Attorney General's Department, and we consult extensively with them. We have various law reform proposals get put to us and we comment and we have meetings about it and so forth. And also, not only with AGD, but also the various law enforcement agencies will often come to us to discuss various law reform. But we don't have a direct involvement in terms of that sort of education piece. It's more an indirect involvement in terms of, sharing our experience and our knowledge with the different agencies.
So in relation to this new legislation, do you see that this is going to be beneficial in terms of speeding up and having successful prosecutions?
Well, we've certainly had prosecutions that have involved legal practitioners and real estate agents in terms of money laundering matters. I think one of the challenges when you or investigators are executing warrants in relation to legal practitioners is that there's potential for LPPs, so legal professional privilege claims, which can be litigated. I think probably AFP is in a better position to talk about the delays that can contribute to investigations. But it's probably more about identification of where money laundering is occurring through facilitators in terms of the tranche 2 reforms, which will assist law enforcement in terms of their investigations.
Great. Thank you very much. No further questions. We're almost out of time. So thank you both for appearing before us today and the work that you do as well. So thank you. And
thank you very much.
Thank you.
We'll call up ACIC to come forward. Good morning. I now welcome officials from the Australian Criminal Intelligence Commission. I understand that information on parliamentary privilege has been provided to you and also outlining the protection of witnesses giving evidence to parliamentary committees. And could I ask you each to state your full names and capacity in which you appear today, please?
Good morning, Chair. Good morning, Committee. Matthew Rippon, the Deputy CEO of the ACIC. Good morning, Chair. Good morning, Committee. Adam Meyer, Executive Director, Mission Coordination and Analysis Division.
Good morning, Chair. Good morning, Committee. Jason Halls, National Manager, Collections Operations South.
Great. Welcome to you all. Before I ask if you want to make some opening comments, I just want you to be aware that Senator Antic is online, Deputy Chair Mr O'Brien, and of course Mr Ravioli. You may not recognise him, but the younger version is with us here today. So welcome. Mr Rippon, would you like to make some opening comments?
I would if you'd indulge me for a few minutes, Chair. That'd be great. Thank you.
I appreciate that. Thank you.
Chair, thank you for the opportunity to provide some opening remarks to the committee. As the committee knows, the ACIC is Australia's national criminal intelligence agency with a focus on the serious and organised crime threat environment and its impact on Australia. Our purpose is to protect Australia from serious criminal threats by collecting, assessing and disseminating unique, actionable and insightful criminal intelligence and policing information. We've recently publicly reported that the cost of serious and organised crime to Australia is estimated at $82.3 billion annually, a figure that exceeds Australia's annual defence budget. The organised crime environment continues to fundamentally shift. Criminal networks targeting this country are increasingly globalised, work across state and national borders and are exploiting geopolitical, economic and social uncertainty to maximise their profits. From a money laundering perspective, the ACIC works with partner agencies to generate new insights into significant criminal networks, their methods and enablers to combat money laundering and financial crime impacting Australia. Organised crime networks target Australia's banking, investment, superannuation and tax sectors, as well as individuals, businesses, along with government departments and agencies. At a cost of $13.2 billion annually, financial crime represented the second most significant cost to Australia in 23-24, trumped only by the $19 billion a year illicit drug trade. The clandestine nature of money laundering and its increasingly diverse channels make it difficult to pin down the true scale of illicit money flows globally and impacting Australia. However, it continues to threaten our national security and our economic stability. The Australian Institute of Criminology, who our CEO oversees as Director, has made estimations around proceeds of organised crime generated from illicit drugs, various financial crimes, intellectual property crime, firearms trafficking, pure cybercrime, identity crime, corruption, and the lost tax revenue from illicit tobacco, amongst others. Interestingly, the total proceeds for all serious and organised crime was almost $38 billion, representing the total pool of funds available for laundering in Australia. Now, this doesn't cover committee proceeds of crime generated outside of Australia and brought into this country. The global reach and adaptability of money laundering networks and professional facilitators present complex and shared challenges for domestic intelligence and law enforcement agencies, international partners and, of course, industry. The ability to rapidly and efficiently move illicit funds across borders through evolving fintech avenues grants criminal groups access to jurisdictions and markets that may otherwise be out of reach. Dedicated money laundering organisations exert their global reach through the use of cryptocurrency to move both legitimate wealth and the proceeds of crime across borders, often commingling proceeds from multiple and varied ventures in an attempt to disguise their activities. We are certain they will continue to evolve their business model where vulnerabilities appear in systems. We have direct and clear intelligence of professional facilitators, corrupted, trusted insiders and in some cases unwitting professionals engaged and weaponised by organised crime, in some cases strategically placed in critical vectors of the global supply chain to enable money laundering to thrive. As the threat evolves, our intelligence enforcement and regulatory agencies are having a significant impact in the fight against serious and organised crime. The committee, I think, can have confidence, Chair, that the intelligence, law enforcement and regulatory agencies that appear before you more determined than ever to coordinate our activities to create the most hostile operating environment possible for organised crime. Thank you, Chair. We're happy as a team to take your questions from the committee.
Thank you very much. I think you summarised perfectly why we're having this inquiry in terms of the damage of organised crime and money laundering has to our economy and our people. Can you explain for the committee why the money laundering and financial crimes are so difficult to identify and measure?
I'm sorry, I missed the second part of the question. Sorry, Chair.
Just in terms of money laundering and financial crime, can you explain why it's so difficult to identify and measure what's happening out there when so much of it is happening outside of our physical borders?
Yeah, I can, Chair, and I'll also call upon my colleagues as well, but any clandestine type activity is really difficult to measure the true scale and impact. So it's always difficult for us to, as I said in my opening statement, really pin down the true global nature. These are what I would consider quite conservative figures if we look at the span of activity that we have from an organised crime perspective. But the business model of organised crime is centred around making money and causing harm, but primarily the motivation for organised crime across so many streams of their activity is to make money. So they will take all and every effort to make sure that they are concealing their activities and their wealth. They will look to exploit any vulnerabilities in the system, whether it be supply chain, financial system, the banking sector, and they will move and adapt into those vulnerabilities to take advantage of opportunities to make money. Just this morning I read, Chair, an article that appeared around an NDIS fraud, another NDIS fraud, $200,000 made using fake identities and then driven through the system to be able to generate huge amounts of profit for organised crime. And that's one small example of organised crime being adaptive and being able to jump into the vulnerabilities that are in the system. I don't know whether my colleagues want to add anything further, and hopefully that answers part of your question.
It certainly does. Thank you for that. What we need to assess and be helpful to have some evidence around the current capabilities of law enforcement to be able to deal with this growing borderless crime. Technologies moving rapidly, AI. Are we able to actually combat this with the capabilities that we currently have? And I know everyone will say, yes, we can all get and use more money, but the reality is the crimes are so more difficult in terms of combating them, but do we have the resources? Have we got the capabilities? Does there need to be, bigger recruitment into law enforcement, more money spent on technology, more training on AI?
Chair, I don't think you'll have any senior public official come into a room or a parliamentary committee that won't say they can't do more with more resourcing. However, we're really satisfied with our approach across government, both domestically and internationally. We're a member of a range of task forces, as you would be aware, some of them AFP-led, some of them led by the Australian Taxation Office, like the Serious Financial Crime Task Force. The AFP-led Avarice Task Force is very much money laundering focused task force, and I know that you're speaking with them today. We have AUSTRAC members embedded into the ACIC now. We have a joint team that approaches money laundering and the many enablers that sit around money laundering within the ACIC to properly capitalise on data sharing and the capabilities of both of the agencies. I think one of the challenges that we have as we move forward is that organised crime are adapting so fast and adopting technologies at such a rapid rate that we need to continue to be looking for opportunities to grow our workforce and diversify our workforce, diversify our training, so that we are moving at the same pace as organised crime. It's a real workforce challenge. We talk about technical literacy, cyber literacy, crypto literacy. These are all things that I would never have discussed with you when I first started 32 years ago, but they're certainly on our lips as we look to recruit people into our agencies with the budget envelope that we currently enjoy. On the international front, I know that Mr Halls and a range of other of our staff within the ACIC are constantly attending Five Eyes meetings globally, where we are sharing best practice, where we are looking for opportunities to engage on joint operations and intelligence sharing. That will only escalate as the threat continues to escalate. Global problem, global harm, getting a better sense of those international money flows impacting Australia is a challenge for us that we take on, but we don't take on by ourselves. We're doing it in complete partnership.
So in terms of the main challenge that ACIC are facing, would that then be around recruitment, and I understand from your evidence you just gave us, but are there any other major challenges for your agency in dealing with this type of crime?
I think, Senator, dealing with the pace of technological change is something that gets close to keeping me awake at night. And as we look to continue to recruit and as we continue to train our workforce, we need to be focused on making sure that our capabilities are keeping pace with that of our adversaries. So that's the thing that probably keeps me awake, or close to keeping me awake at night, in terms of our capabilities in addressing the money laundering and financial crime threat. I think you can take some confidence, and you'll probably hear it from partners as they come into the room today, that we're well connected and we're leveraging each other's capabilities regularly. We can't do any of this alone, and certainly, our law enforcement partners can't arrest their way out of this problem. There has to be a new thinking and new approaches to this, and it means bringing in some pretty bright people into the agency when you have got the capacity to do so.
We had evidence yesterday from some universities and also speaking about new courses that are being available to allow degrees in this type of work to happen, so that we've got a bigger pool of people to recruit. Does your agency have any collaboration with any of the universities around research in relation to these sorts of crimes, or the sort of people that you would be looking to recruit?
We certainly have some formal relationships with some of the universities around the countries with some of our other work, like our wastewater testing, etc. In terms of formal relationships with them to secure a recruitment pipeline, if you like, for the agency. No established formal relationship there, but constantly scanning the environment with tertiary educators around what courses are available and how we might be able to then attempt to recruit people in. We're certainly taking, under our CEO, a much more forward-leaning approach into our public image and into how we present ourselves into the public, with a mindset to give people a better awareness around the mission that the ACIC has, which is a really strong mission, and one that I know is very attractive for many young people and others who are in the university sector. Our outreach and engagement function will be focused into the future on attempting to get out to universities, etc., to be able to speak to the wares of the agency and the mission of the agency, to hopefully help them in making some really strong career decisions towards the ACIC and the broader national intelligence community. Because what we do see we've talked about it in this committee before, one of the challenges in the national intelligence community and across law enforcement is that a younger generation tend to bounce around from career to career. If we can keep them within the national intelligence community and keep them within law enforcement circles, working really closely with our partners to provide pathways in and out of partner agencies is a really good way to retain talent and to retain some expertise and grow expertise that can help us certainly enable our tech literacy, which is something that, as I said, is a real challenge for us.
Thank you. Mr Rapicoli?
Thank you, Chair. Yeah, I do. Do you guys have an estimate of how much is being laundered in this country? Like what kind of dollar figure is being laundered in this country?
Thanks, Mr Rapicoli. Thanks for the question. I think in the opening statement, it is very difficult to pin down, but what we do have is a picture of what looks like the pool of proceeds of crime that sits within the country at any point in time, and over the 23-24 period, that was that figure that I was talking about, up anywhere towards $38 billion, and that's generated from all of the predicate type offences that are occurring across the sphere of serious and organised crime, whether it be firearms trafficking, drug trafficking, major fraud, etc. So we would say that domestically that there is the availability of a pool of money of around that figure.
Thank you. And you guys come and see us regularly, so thank you for the information you guys give us. You guys give us some really good insights, sometimes scary, may I say, but very, very good insights. And you said that there's an amount that's coming in from offshore, from money laundering offshore as well. Do you have any idea where that is as well in the monetary figure?
Yeah, no, I don't have figures in front of me. I could take the question on notice,
that's okay.
Just to ensure that we're displaying our appropriate due diligence around the question, Mr Rapicoli, but I can't pin down a number, nor have we commissioned research, nor have we got the sophistication just yet to have a complete appreciation, and that would be a whole of government effort to come together with that sort of figure. But it would be significant because if we think about the threat of serious and organised crime to Australia, as we've briefed before to you in both public and private hearings, 70% and beyond of the serious and organised crime threat to this country emanates from offshore. Therefore, it's natural to have a comprehension that there would be significant flows of money coming into the country as well as going out of the country. We would also have to consider the impact of other foreign jurisdictional controls and what impact that might have on the availability then of money channelling into Australia to avoid those controls in other countries.
Yep, thank you. And you said your main challenges are around that recruitment and pace of tech change. So with the recruitment, every industry in this country is in the exact same situation. Every department's in the exact same situation. It doesn't matter whether it's you guys, or it's a tax office, whatever it is, or whether it's the fitters, the boilies, the lecos. Doesn't matter where we are, the road crews, the maintenance crews. We are short everywhere. What are you doing that puts you above the rest to get more people to come and work and be in this industry that you've been in for the last 32 years?
Yeah. There's a range of things that you can do, Mr Rapicoli, and one of those things is that we're in the throes of doing right now, and that's building our public profile. You may have seen our CEO address the National Security College recently to really bring an additional profile into the community around the harms from serious and organised crime and the mission that the ACIC is embarking upon. What we find is that when we talk to the people that are coming into the agency, the thing that is attracting them to coming to the ACIC isn't necessarily the public service pay arrangements. It's the mission that they are attracted to. So continually pushing out and promoting the mission of the agency is a really important aspect to recruit. It's difficult though, isn't it? Because, as you say, we're in a competitive market where there are only a certain block of resources that are available. I think one of the challenges for us in the future is how we responsibly and ethically start to build our AI literacy to be able to continue to build capabilities to extend upon the very, very good men and women of the ACIC that we have at the moment, and that's something that we've got an eye on, noting that whole of government guardrails are being set up from a policy perspective to guide agencies into how they would approach the adoption of AI. But we're certainly adopting AI at a low scale and accelerating that. So I think that's another avenue where, in the absence of being able to attract bulk people into the agency under our budgetary envelope, we are looking for new ways of adopting technology and moving with the threat.
So I'm glad you brought the AI into that answer there as well. What are the barriers that are holding you guys back from getting more advanced and a lot more into AI than what you currently are?
I'm not sure whether or not there's barriers. I mean, unlike serious and organised crime who have no rules, they can just deploy technology as they see fit. We have to make sure that we're acting lawfully and that we are approaching any use of AI with a human lens over the top of it. We don't wish to find ourselves in a scenario where we are misleading the public or our partners or the Parliament in the execution of our powers or the collection of evidence and then our assessments that flow on to advise government. So we need to be really conscious and careful about making sure that those guardrails are sufficient, but at the same time not chaining ourselves down to operate at such a slow pace that we can't keep up with serious and organised crime. So barriers are always there, and budgetary barriers, etc., are just a natural thing. The government's only got a certain envelope of money and a range of priorities that we understand that they need to deliver for the Australian public, and we do our very best with the budgetary allotment that we are fortunate to be given, and we're very fortunate to have the support of the Parliament around some very significant powers that we can apply both in the money laundering sense and through all other aspects of organised crime.
And the pace of tech change, you said, is another major issue, and obviously AI is part of that. We always seem to be playing catch-up to what the Crims are doing, and as you said, that's because they have no morals, they have no laws they've got to go by. What is the new thinking around how we can really get on top of this and actually maybe for once be in front of them? What is the thinking outside of the box that we need to all do differently from you guys and then us from government as well and being in this building? What does that look like?
Well, I think there are some agencies internationally that are doing this sort of work and are making advancements from a best practice perspective. I'm not long back from an overseas trip where I met with the US FBI, DEA and Homeland Security Investigations. I also went over and met in the UK with the National Crime Agency and up to Canada to see the Royal Canadian Mounted Police and other agencies that we are working very closely from a Five Eyes perspective. I think really trying to leverage and learn best practices from our partners as offshore and not being scared, Mr Rapaccioli, to really engage with industry and noting and acknowledging that there is always a commercial motivation from industry, approaching them with the right intent around what we're trying to achieve and helping them understand our mission will often bring them closer to us to be able to share and for us to be able to adopt the next set of technologies that might be coming forward. It all costs money, but there are different ways to skin the cat, as you might say, in trying to adopt technology. But I think by engaging with our Five Eyes partners and really soaking up best practice, we're going to put ourselves in a better position to collectively act as that global intelligence and law enforcement team to get in front of serious and organised crime as best we can.
And so my final question, Chair, what can we do more with the public? Like most of the public, 99% of people don't want to see any crime, don't want to see any of this. They would have not a big idea and understanding of what is actually happening in this space. They would be horrified if they knew exactly what was going on. And then if they do know what's going on and they do find out that there's some crimes happening, how can we utilise the public more to be helping you guys, to be helping our police, our AFP along the way? Because quite often I know I hear that anything that gets brought up quite often by the public just falls on deaf ears. That there's no interest in it, that it's too far-fetched, there's no way known that's happening. How do we get, like, you guys are the cream of the crop, right? But how do we make sure our other law enforcement agencies are all doing the right thing to get the info to you that is happening every day, that everyday people are seeing in the public as well, which would make massive differences to help you guys along the way?
It's a great question, and look, when you think about it practically, you've got 26, 27 million eyes and ears that are out there every day. They are, I'm going to crudely say, they're intelligence collectors, potential intelligence collectors. I think that's part of your point.
Certainly is, yes.
There are a range of, and I don't want to necessarily speak for my law enforcement colleagues, but I did come out of the AFP with a couple of decades of time in that agency, and there are a range of avenues for the AFP and our state and territory law enforcement agencies to secure raw intelligence and raw information to then analyse and provide to us as part of what are regular coordinated meetings, and we want to assure the public that we've got regular coordinated meetings. Part of the ACIC's function is to bring the system together across law enforcement and intelligence to be able to stitch together that intelligence picture. It's disappointing to hear from time to time from perhaps your constituents that they have information that they want to share and that they feel that they're not being heard. Again, I don't want to speak for our law enforcement colleagues, but there are a range of avenues that they can pursue to push information into the system that will get to us. And I want to give you assurances that we are getting both raw and well-advanced intelligence from our partner agencies for us to then add our own analysis to and come to assessments and conclusions and deploy capabilities and deploy intelligence packages to our partners for them to then apply operational effects to the problem. So, yeah, I acknowledge the frustrations of some of the public, but there are a range of avenues for it to get to us, and I have a high level of confidence that much of that is occurring. But we can always do better.
Sorry, could I just follow on with one other question, Chair?
Yes.
Thank you. Would you be able to get us the information that we can get out to our electorates? We can get out to for the senators, for their duty areas and things like that as well, just so that we're given the right information out there as well of exactly how they can contact the right people in this space. And it's easy for us to say, well, you just got to get in touch with the local police station, but they do that, then they may get fobbed off and they're never ever going to do that again. Yeah, and that's a lot of information quite often that we've missed for whatever reason or another. Could you get us the information of what we can put out there into our communities to make sure that they are getting the best possible information of where to go to?
We'll take the question on notice, and we'll do our best to coordinate through our partners. We do that normally anyway, coordinate through our partners to be able to give you the best information we can for you to be able to connect with your constituents, and I think that's a noble cause for us to all be doing.
Thank you. Thank you, Chair.
Thank you. Just a wrap-up question. The new legislation, which now is going to encompass lawyers and accountants in another avenue of trying to detect and counter their money laundering. Do we need to go further than that? We've had evidence from other witnesses yesterday in relation to should it be expanded out to luxury goods, art dealers, even livestock, jewellers, in terms of, with all these crimes, organised crime, it's all about money. It's about money and they have to launder that. And we know when there's sieges, there's, very luxurious cars and lots of other things. Should there be a requirement placed on those who are selling luxury goods, dealers, caught under this legislation going forward?
I mean, I'd hate, Senator and Chair, to line up our AUSTRAC colleagues for the regulatory burden that might provide for them, and I know they're appearing before you later, but, as you pointed out, serious and organised crime will try and conceal their ill-gotten gains through the purchase and layering of a whole range of of purchases, etc., whether it be luxury cars, luxury jewellery, real estate, etc., and that the Tranche 2 reforms address some critical gaps that we as a community highlighted through submissions that were made to this committee and others. And I think they will go a long way to addressing some of those really critical gaps. Don't know whether or not you've got anything else to add, gents. But in terms of expanding the regime even further, look, we would obviously see an intelligence dividend with that. We would have access to more data and more information as a consequence. I do fear of the extended sort of regulatory burden that would place on AUSTRAC and others. But I think as these Tranche 2 amendments come into play, giving them a little bit of time to settle and understand the impact that they're able to have will be a really important step. And then our job from the ACIC perspective was to keep committees like this informed about where the threat is pivoting to, so that we can then give you advice on where we think other legislative provisions may need to be considered or adopted. That would be my advice to the committee.
Yes, I agree. You need to bear down this changes first, and obviously, if you're going to put more onus onto AUSTRAC, then they would have to be resourced appropriately. But if you now we've include accountants and lawyers, what will happen is the bad guys are going to move to another area. You know, they'll still use those that are weak within those regimes, and they'll still use them, but they will continue to look for other avenues that is going to generate the opportunities for them. So,
I agree.
Yes?
I agree with your assessment, Senator, and sorry to cut you off. I think that displacement effect, this is part of the role of the ACIC, to have a look at where potentially organised crime might be displaced to as a result of the introduction of the Tranche 2 amendments. And if we are in a position to do that as dynamically as possible, then we're in a much better position to then attack organised crime collectively rather than playing catch-up and having to come back to you urgently for legislative fixes.
thank you. And yesterday we had evidence in relation to some of the questioning about, you know, what countries are ahead of Australia, because it has taken us some time to get to this point. And obviously England, France, Germany and the Netherlands were all included in that list. Is there, in your view, I know how important it is to have this international collaboration, but is there anywhere else that you believe that we could learn some practices, and are there any that you know of that include luxury items already?
Chair, more involvement with the community of practice in the Five Eyes. Certainly luxury goods, serious organised crime looking to spend their wealth that they've generated. So, yeah, there's been certainly some progress there on that, the luxury goods side, whether it's handbags, jewellery, etc.
Thank you. We unfortunately, as always, have run out of time. We could continue this, I'm sure, for days, but thank you very much for your submission. And most importantly, thank you for the work that you do every day, and we appreciate you giving up your valuable time to keep this committee informed. So thank you very much.
Thank you, Chair. Thank you, Committee.
Thank you, guys. Cheers.
And then we'll call up our favourite to everyone's agency, the Australian Taxation Office, to come forward, please. Yes, and then we've got Australian Securities and Investment Commission, and of course we have Treasury.
Some would say the A-team. Have a look at them all together.
Well, it is the time to be nice to the ATO at the moment, I think. Good morning, everyone. I now welcome officials from the Australian Taxation Office, Australian Securities and Investment Commission and Treasury. The Parliament has resolved that an officer of the Department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked by the officer to superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to parliamentary committees has been provided to you for the Hansard record. Will you please each state your full names and capacity in which you appear before us today? May we start from the left?
Sure. Thank you, Chair. I'm Rebecca Feely, Assistant Commissioner for Intelligence and Assessment Centre at the ATO.
Thank you, Chair. Barton Hoyle. I'm a Director of the Legal Policy Unit, Treasury's Law Division.
Chair Kim Demart, a Director in the Corporations Branch at Department of Treasury.
Thank you, Chair. Claire Mackay, Assistant Secretary of the Payment Scams and Innovation Branch.
Thank you, Chair. Lauren George, Director of the Scams Legislative Policy Unit in Department of the Treasury.
Thank you all, and we have people via video.
Thank you, Chair. I'll state first, Scott Gregson, I'm the CEO at ASIC.
Thank you, Chair. Chris Savandra, I'm the Executive Director of ASIC's Enforcement and Compliance Group.
Thank you. Welcome to you all. As you can see, we have Mr. Rapicoli here with me today, and we have Senator Antic on telephone, and also Mr. O'Brien. So thank you for giving up your time. Is there someone going to make an opening comment or give a statement at this time?
None from the ATO beyond the two submissions. Thank you, Chair.
Treasury? No?
None from Treasury either.
ASIC?
We'll rely also on our submission. Thank you, Chair.
Great. Thank you very much. Mr. Rapicoli, would you like to start with some questions?
I'll start with the ATO today, please. What is the ATO's role in identifying and addressing money laundering and financial crime?
Thank you for the question, Mr. Rapicoli. We've the ATO's...
I'm sorry to interrupt, but can we either turn up the microphones or you have to
or just
be a bit closer?
Speak a little louder.
It's not very good in this room.
Yes, so the ATO has a role in addressing money laundering and financial crime through a variety of mechanisms. In particular, we have joint leadership of a range of task forces or membership of task forces that focus on financial crime, money laundering and related matters. We also have a role in terms of supporting law enforcement agencies with investigations and through sharing data and intelligence that the ATO has in support of traditional law enforcement agency scope and remit. And certainly from a tax perspective, there is a strong relationship between money laundering and ensuring that we identify and collect the right amount of tax on obscured sources of income or indeed even proceeds of illicit activities that are undeclared to us.
And what are the main financial crimes out there that these groups are doing?
Yes, sure. So I think in terms of size, we would probably say that our estimates around the shadow economy probably constitute the majority of primary offence types, if you like, that then involve money laundering to be able to hide those that type of income. Our recent tax gap estimates that we've published talk about in the vicinity of $25 billion for the 22-23 financial year, which is quite significant. and bears a relationship through to money laundering. We also have seen a rise in other crime types such as identity crime as well, which we counter through our counter fraud program that the government has invested in order to ensure that we have adequate controls in place in terms of authentication and access arrangements. This is where the crime is around identity takeover and illicit claims of refunds, such as other government payment programs also experience. We also have that at the ATO.
Thank you. And can you explain the key coordination bodies involved in who you work with?
Yeah, sure. So one of our key task forces that we lead and coordinate across government agencies is the Serious Financial Crime Task Force. It's a multi-agency body, so it covers the Federal Police, AUSTRAC, the Criminal Intelligence Commission colleagues who've just appeared, our colleagues online from ASIC, Border Force and the CDPP, as well as other members. We use that to help coordinate resources and the different types of actions that fall within legislative remit of member agencies to investigate and tackle complex financial crime.
Thank you. And what are the main challenges facing the ATO right now?
I think probably the different the change in the way that money laundering is being experienced. Certainly, we've seen some changes in terms of what used to be considered the cash economy is now a lot more digital than it used to be, with the rise of things like electronic sales suppression software that are used in order to operate in the shadow economy without the need for cash, and keeping up there is something that we're tackling strongly through our shadow economy task force.
And what would the solutions be for that key issue? What would they look like?
So we have a range of different mechanisms that we use through the shadow economy. It's not my primary area, but what I can say around that is that we certainly identify those operating outside of industry benchmarks using data matching within the ATO. We also identify businesses that are underreporting transactions and income or overclaiming expenses through those means. So we collect intelligence and data in order to ascertain what might look out of sorts to investigate further. And we respond to community tip-offs, more than half of which are related to shadow economy activity, and we've received more than 300,000 of those community tip-offs since the establishment of our Tax Integrity Centre.
That's good.
Yes.
That's very good. And so all those tip-offs that are just coming from the public, do they all get treated the same, or do some? Because some of you may have heard my question earlier to the previous witnesses. Quite often, we've got 27 million eyes and ears out there on the ground that are our best information gatherers everywhere. Quite often, when they put that information forward, they hit brick walls and nobody wants to listen to them.
Yes, thank you for that question. So we do assess every tip-off that comes in from the community manually. So they all have human eyes over them. It doesn't necessarily mean that they're all treated the same in terms of which action we might take, but at a quantum of around 50,000 a year, that is quite a lot of attention that we pay to community tip-offs, and ensuring that we do the best we can with all those signals adding up and pointing us in the right direction for our priority efforts.
Excellent. And can you just inform us how the community can actually go and register if they have something some important information they can pass on to you guys?
Yes, sure. So if they go to ato.gov.au and search for tip-offs, they will find a web form that enables them to record their observations or allegations on our on our webpage, which then goes through to a team that assesses each one.
Thank you. And in your submission, you noted that there were legal limitations to sharing information to government partner agencies, but that these limitations were not significantly detrimental to addressing the most serious instances of money laundering and financial crime. Are you able to just tell us a bit more information on this and what those limitations are and what impacts they have along the way as well?
Yes, sure. So I will just emphasise the point that we do have exemptions in place already under current legislation that does allow us to address the most serious offences and enables us to share that information. So that is in our Division 35570 section in particular, which allows us to share with law enforcement agency partners around serious offences and that might be being investigated by our partner agencies. And I note too that we have our colleagues here from Treasury who are looking at proposals for further exemptions to the secrecy provisions at the moment, so I might defer their consideration to that. But one other thing that I will just note is that we are being as progressive as we can in terms of our use of the current legislation, and within the last 12 months we have started sharing proactively information to the Australian Financial Crimes Exchange, which I note has been mentioned in some of these submissions. So that allows the ATO for the first time to be able to share barred bank accounts in particular, of which we've already shared more than 50,000 to members of the Financial Crimes Exchange. And that is able to be done under our current legislation, but is constrained in terms of which members are able to legally use it. And so there are some proposals that perhaps I can defer to Treasury to cover off more on that would help us unconstrain that data sharing.
Yep, no worries.
Yes.
Happily defer to Treasury.
Yeah, I can take that one. My unit's been looking after the review that was mentioned into tax secrecy exceptions. So just in terms of scope up front, just wanted to clarify that our review isn't looking at the broader framework. So essentially, a tax secrecy framework, the default is taxpayer confidentiality and then sharing in certain specific exceptions. And so it was good to hear that the exceptions that currently exist are working well in terms of task forces and also sharing with law enforcement agencies. So our review that's been going on, I think we consulted publicly the back end of December 2024 and through to February of this year. We tested some proposals where we think it's more around fine-tuning and ensuring that if we've identified any gaps where there might be a strong public benefit, enabling greater sharing of tax data, that we interrogate those and look into the argument for taking those further. In terms of what we've looked at that would be relevant to this inquiry, in the law enforcement agency space, we identified that there are some agencies, particularly AUSTRAC, that does have responsibility for investigating serious offences, and the ATO can currently share data with AUSTRAC, as you probably heard, through task forces, but can't share directly with AUSTRAC for the investigation, to support the investigation or enforcement of a serious offence. So that was a proposal that we tested in our paper. The other area that was referred to was this gap where the ATO may come across information or be approached as part of its involvement, I think, in the Australian Financial Crimes Exchange for information. And because our exceptions are currently focused on sharing with government bodies, not sharing outside with private sector, that was a significant reform that we've tested through the paper. And we have, consulted on whether what the ATO can currently do, where there's a nexus to tax fraud, is broad enough, and there does look to be a gap in terms of being able to share to prevent fraud in certain circumstances. So what that model looks like would need to be fleshed out, and I can refer you to sort of our part of the consultation paper that maps that out. But that is something we're looking at, enabling the ATO to have greater ability to share information with the private sector in certain circumstances, but it would really need to have appropriate safeguards, including the type of information that was provided, and also a really close look at the actual entities or the fraud prevention programs, what they would actually look like before that would be progressed.
Just my final question for this little round, Chair. So with the exemptions, and I'm glad you're both talking about the exemptions here, what are the parameters around that of what is exempt and what isn't, and what you can share and can't share, and are we making it easier for money laundering to happen and financial crimes to happen and be committed by not having this scope big enough for these exemptions?
Did you?
I can talk a little bit about that, and perhaps you can too from a policy standpoint. But certainly we have existing exemptions that allow us to share to a degree under certain circumstances and within the guardrails of each of those exemptions. The key one, as I mentioned before, is under our Section 35570, which includes a table of specific prescribed task forces, as my colleague here has mentioned, but it also has an overarching law enforcement serious offence exemption for sharing. And in addition to that, the other legal provision that we can use in certain circumstances, such as for the sharing with the Financial Crimes Exchange, is actually our Division 35550 in the course of duties. But we have to have a nexus back to more effective tax administration as a result of that. So what that effectively means, just to the degree this explanation helps, is that we need to be able to show a legal reasoning line of sight between if we were to share things like bank accounts that the ATO has barred with a body like the Australian Financial Crimes Exchange, that it only goes, the information is only shared to members who can take action that actually assists the Commissioner in more effective tax administration, in this case banks, that might be able to take action on associated accounts to those barred accounts, which might prevent us from paying refunds to those who are not entitled to them. But so as you can see, we have supported the proposal with Treasury and their consultation paper to make that less complex and less constrained, so that we might be able to share this information for the purposes or for usage, which might prevent broader scams that are not tax related in the community through a body like the Financial Crimes Exchange.
Could I just add one little bit? Is that okay?
Again, this is the second time. Yes, you've got me for. With
you guys are all fantastic government agencies, right? And this is more Treasury than probably you, I would say. You guys all have got the highest level clearance in so many different areas and things, right? Why do the exemptions have to be there when you're all trying to do the best thing to stop money laundering happening? Like, if the general public say that you can't talk to this department, you can't talk to this department, I can't talk to that department, when you all have the same level of clearance, you all work in high crime areas, why is there got to be these strict parameters there to be able to have these conversations between agencies?
That's probably one for me.
Yeah, was more for you, yes.
Look, I think I could talk at length about this, and maybe we can provide some more information to the committee if that would be useful. But really, the fundamental point is 2010, the tax secrecy framework was overhauled and looked at really closely by Parliament. So the settings that we've got, and they allow us to create these exceptions, but I understand your question. It's like, why do we have to sort of have these specific exceptions? And it really comes down to an assessment of the importance of taxpayer confidentiality for the integrity and trust in the tax system and dealing with the ATO, And of course, you have to balance that with the public interest of sharing information when it's in the broader public good. So that's what the system allows us to do through the exceptions, and that's what our review is trying to do, to see if there's any gaps. If we enable broad sharing that isn't sort of within the framework, the rationale is there's a risk there you can undermine trust and confidence in taxpayers dealing openly and transparently with the tax office, which could have significant flow-on effects for revenue and other aspects.
Okay, I've used enough of my questions. I could go on a lot more, but I won't for the minute.
Oh, thank you. We may have time to come back, but Mr O'Brien, you have a question?
Yeah, thanks, Chair. Look, just onto a different area. Illicit tobacco is a massive problem around the country. Every member of Parliament I speak to in the lower house, at least, has certainly it's got a story to tell about it. The sale of illicit tobacco, the scale of the market's often measured by lost revenue, and we hear the taxation department involved in this conversation. What interaction does the tax office have with this problem, with this crime? And if you could just expand on that, or let me know first on that, thanks.
Yes, thank you for your question. It's not my personal area of expertise. However, what I can say is that the ATO remains very active in the illicit tobacco task force. Our focus within that task force is domestic production, which is the thread that we have the lead on. Domestic production, as you may be aware, is not the primary amount of illicit tobacco in the community. Border Force have the lead on the illegal importation. And I know you have Home Affairs on later on the agenda today. But we certainly work to support where there is a appropriate need for the tax officer's involvement with the illicit tobacco task force, including the support for the Border Force-led thread of activity under that task force for illegal importation. So yes, we remain very active in trying to combat, where appropriate, that particular problem in the community.
Do you have a specific section in the ATO that deals with illicit tobacco, or is it just part of a more broader group? We do have units within areas of the tax office that undertake their functions to help support, and we do have a designated coordinator for the ATO's involvement in the illicit tobacco task force. In particular, our criminal investigations team undertakes a lot of that effort to support that cross-agency task force from within the ATO. That's all from me, thanks.
Thank you, Mr O'Brien. I want to focus now and have some questions for Treasury. Several witnesses yesterday raised the issue in relation to the beneficial ownership register, and they've obviously spoken about concerns about the implementation, how long it's taking. So I was wondering if you could talk us through the register, how far it's progressed, and what the criteria is. There's been evidence that there was a view that it would be started from scratch. And if you could give us an overview of that, and what countries and have you looked at in terms of how successful their registry has been implemented?
Certainly happy to give you a quick overview. Treasury's been charged with policy development work in relation to implementing a public register of beneficial ownership, which is consistent with an election commitment with the current government back from 2022. Work commenced on that back in 2022, as I mentioned. The Treasury issued a consultation paper in December 2022, which set out key parameters for a beneficial ownership register. It was in relation to corporate entities, so companies more broadly. The work has been split into two streams, given the nature of the different nature of listed companies and unlisted companies. So work has been progressing through separate streams for those two categories of corporate entity. In relation to listed companies, there's currently, following the consultation in December 2022, an exposure draft legislation was released towards the end of last year, and reforms to the existing statutory framework for beneficial ownership disclosure of listed entities were introduced in a bill over the last, which is currently before the Senate, the Treasury Laws Amendment Strengthening Financial Systems Bill 2025. The listed entity reforms build on existing arrangements because of the different nature of listed companies from unlisted companies. They're typically, they have a broad ownership, so beneficial ownership in those, and ownership of them turns over quite quickly because they're listed on a financial market. So there's a different arrangement there, but there is a register, what's called the Register of Relevant Interests, which is a register that's been meant to be kept by listed companies for some time. The bill enhances the existing framework around that register, as well as substantial holding disclosure framework, which is currently in place for listed entities. The enhancements include bringing equity derivatives within the scope of those provisions and increasing their application to foreign entities listed on the ASX and other financial markets, as well as enhanced enforcement capability for ASIC, including the ability to freeze shareholdings where there's been non-disclosure and to make interim orders in relation to that. So those reforms are currently before the Senate. In relation to unlisted companies, the consultation paper received significant feedback in a number of areas. What was originally proposed was a two-stage implementation process whereby companies themselves would maintain a beneficial ownership register on their own system. So we referred to that as a sort of a decentralised register where each individual company had one that they maintained, ahead of it moving to a second stage where a public Commonwealth operated register would absorb the information from those registers once an appropriate IT build had taken place. And the government on the 15th of October, in December last year, quite detailed policy specifications around that register were released. So information around access to the register, what kind of fields would be on the register, what information would be available for different purposes and for different users was set out as part of that first stage for the decentralised register. Following further consideration, including of feedback that was received in 2022, the government announced on the 15th of October that it would proceed directly to the second stage public Commonwealth operated register, and therefore the focus now has been on adapting those policy specifications for a world where we go direct to a public operated register.
So how are you going to, I think we're going to run out of time, but how do you then identify whether a director on a company is a real person, whether they are not a 3-year-old child that someone set up as a director or somebody who's in aged care and has dementia? How is that going to be scrutinised, and so that people can have assurance that it's legitimate?
Yeah. So as part of the the policy proposals released in December, there was a verification requirement. So there's two aspects to this. One is the information that's inputted into the register, so that making sure there's adequate data quality in relation to that aspect of the register. And separately, there's the ongoing sort of oversight and enforcement for the registrar of the registrar to make sure that they've got appropriate powers to monitor on a risk basis or otherwise the quality of that data. So they're two key considerations in the formulation of that register. A key consideration also is the IT, the availability of IT to facilitate that, and also the broader purpose of the register, which is really serving a multifaceted purposes, one of which, of course, is there are a number of benefits in relation to AML-CTF compliance, but there's also broader benefits in relation to tax evasion and other areas of financial crime that are under consideration. So in that regard, one of the key things that needs to happen in part of the policy build is alignment with the IT work that ASIC's currently doing as part of its stabilisation and uplift of its registers. There's been, sorry.
So how, to get to the answer to the question is, if I suddenly was named as a director for 20 different companies, 3 weeks later registered as a director of another 10, how is that going to be verified and how long is that going to take? Is there mechanisms when the data is entered at that time?
So those details are yet to be determined as part of the policy settling for the Commonwealth operated register.
Sorry, but wouldn't that be part of the initial consultation and the establishment of such a register that you go, tick a box, there will be verification of people as that data is uploaded?
Yeah.
Otherwise, the register is useless.
So the very detailed process by which verification will occur will depend on options that are available at that time. So, for example, one of the options that has been under consideration as part of the consultation has been the verification that occurs at the moment in relation to director ID. So at the moment, there's a process whereby directors have to verify their identity through an ATO process, and ASIC is going through a process at the moment of uplifting and stabilising their register to accept the verified information around director identity. So what we've said in the consultation is, to the extent that there's verification processes that need to occur in a similar way in relation to information that's provided around beneficial owners, that the technology available at the time, which will depend in part on the IT build by ASIC and what is available and the broader sort of considerations around the regulatory burden on the users of the system, will be part of the mix in terms of working out the details around exactly how verification will occur.
But I'm sure in the consultation and the design of this register, the Treasury and other agencies would have looked at what's happening internationally to know where those registers are more effective. So in terms of the register and the accuracy of that information that's on there, when are you going to release the details of the plan to be able to verify that these people are legitimate? Because after all, this is a big part of trying to disrupt money laundering in this country, which is costing every taxpayer billions of dollars.
Yeah, so as you quite rightly point out, there are ongoing developments internationally. In fact, from today, there's verification requirements that commence in the UK. So we've obviously been keeping a close eye on developments there. In the UK, directors and what are called persons with significant control, what we refer to as beneficial owners, are now required to verify their identity through a ID check process, and that information loaded up. And that was in response to concerns with the experience in the UK earlier around the quality of data going in, sort of going back to that initial point that I was making. In terms of the ongoing policy work, the government's announced that further policy detail is expected in early 2027. The timing of that is aligned with the IT build that would be happening for the next tranche of ASIC's uplift and stabilisation work. And that's a necessary precondition because obviously any beneficial ownership in relation to unlisted companies is heavily reliant on the company register and its IT capacity.
Great. I might just put out the question to the entire panel. The Australian Federal Police have suggested that it should have access to the register, covert access to the register to assist in their money laundering investigations. Has there been any consideration in the design of that register to allow AFP to have that covert access?
So certainly what was proposed, so the policy parameters for the two-stage process always envisaged that there would be greater level of access for law enforcement to information. So there'd be some information that might be collected that was maybe highly personal, that may not be available necessarily to the general public, but would be accessible to law enforcement for their purposes. There was also a policy parameter that suggested that for those who have a use for that more extensive subset of information for AML/CTF verification purposes would have access to that as well.
Right. What's the time frame then for having the register up and running? Can you just remind me?
So the ASICs confirmed that the next tranche of the tranche 3 of their stabilisation and uplift, which is still obviously subject to government decision, will be in the 28-29 year. So that's around the IT build, but the policy development work will commence before then, so that the law's there to help with the the policy design settled, so that the build can occur with the full knowledge of those policy parameters.
I might just go to ASIC now in relation to the register. Have you got any comments following on from the questions I put to Treasury?
Thank you, Chair, and thank you to Treasury for setting up that policy environment. Chair, as you'd be familiar, there currently is both a companies and a business names register. Responsibility for those registers transferred back to ASIC in 2024 and 2025. Indeed, we welcomed 200 staff back from the ATO in April of 2025, so only just recently. We were funded in the 25-26 government budget process for a 2-year program of stabilising, uplifting the capability of the registers. We were funded for the first 2 years of a 3-year tranche that we call Tranche 2, and then we'll also be seeking funding for continuing funding for our Tranche 3. Activities in our Tranche 2 include further stabilising of the registers, uplifting in their capability, including on those issues that were mentioned by our Treasury colleague in relation to linking Director ID with the registers. That will be a key component to our ID management more generally, which is relevant, I think, Chair, to your questions about how we currently and how we will in the future better ensure that there's integrity with the registration of either directors or other individuals mentioned. The advice given is absolutely correct that our Tranche 2 is currently funded up until 26-27, with the further year of 27 and 28 funding. We need to get those uplifts underway before we'd then be able to build in the relevant connections to to deal with the matters that you've been raising there and Treasury's policy in relation to beneficial ownership.
So how does ASIC, if you could explain and walk us through for the committee's benefit, help to prevent and reduce money laundering and financial crimes in the country?
Thank you, Chair. So, as you'd be familiar, we're not directly responsible for money laundering legislation or investigations. That's the responsibility of either AUSTRAC or the AFP in relation to Crimes Act responsibilities. We do, though, as the Australia's Corporate Markets, Financial Services and Consumer Credit Regulator, our remit does touch across issues that are relevant to money laundering. For example, under the Corporations Law, responsibilities of directors to make sure they're managing organisations, corporations correctly, and we have identified in our submission investigations and action we've taken where we say directors fall short of those obligations. Similarly, it's possible for licensing that ASIC manages, financial services licensing, to be used as an inappropriate vehicle for conduct that might be associated with money laundering. And again, our submission sets out some of the investigation and enforcement activity that we've taken in that space. Like other regulators or agencies that you've spoken to, we have very active collaboration with our partners. We're involved in many of the task forces that you've heard mentioned here. We again set them out in our submission. The final area I'd mention is that, like other submissions coming in to this committee, we're familiar with the use of crypto digital assets that may be increasingly associated with money laundering. We have a remit currently where that relates to financial services. We encourage the government to continue its path towards clarifying the role of digital assets and financial services. That will give us, I guess, greater confidence in the way that we can tackle matters in our remit relating to crypto or digital assets.
I understand in August of this year that ASIC charged 4 people with money laundering offences for their involvement in a sophisticated investment scam in 2021. Can you give us any more detail of that?
Yes, certainly, Chair. I'll hand you over to Chris Savundra, who leads our enforcement teams, and he'll have the details on that matter.
Thank you.
Thank you, Chair.
I can't hear you now, sorry.
What about now?
Yes.
Chair, can you hear me now?
Yes, go ahead.
Great. So, yes, that's right. 4 people were charged with money laundering in relation to a fake investment scam in August of this year. ASIC alleges that between January and July 2021, the 4 individuals were involved in facilitating a sophisticated financial investment scam targeting Australian investors, offering fraudulent bonds and other products, often referred to as bond scams. We allege that the 4 dealt with victim funds which were proceeds of crime and were reckless as to whether those funds were proceeds of crime. We commenced the investigation into this matter after receiving complaints from consumers and corporate and institutional entities.
Superannuation seems to be a lucrative target at the moment. Have you got any details, or can you talk us through the complexity around those sort of scams and money laundering?
Sorry, Chair. I think we just. We'll just use yours.
Yeah. Did you hear my question?
I didn't, Chair. You could repeat it. Apologies.
Yeah. No. Just it seems to me to be, from what I'm reading and what contact that I'm getting from people, is that superannuation is a pretty popular target at the moment for scamming and money laundering. Have you got any examples of that you can share with the committee?
Chair,
So I'm just not sure. You hear?
Yes, go ahead.
Chair, can you hear me now?
Yes. Go ahead.
Yeah. Okay, unmute.
You've gone back
Chair,
on.
can you hear me? Do you want to just use this one, Chris?
Yeah, no.
Technology.
Chair, can you hear me now?
Yes, we can. Thank you.
Yes, we can. Thank you. Yeah, sorry about the technology at our end. We're both in the same room, but obviously having feedback. Superannuation and targeting of superannuation funds continues to be a key focus of ASIC, including an enforcement priority, which we're investing a lot of time in. I think the two areas I would call out more broadly in relation to the intersection with money laundering are investment scams, and the matter that we just talked about is one example. Also other fraud related to corporate bodies. In terms of examples, I'd list a few, and it might give you a flavour of the range of work that we do that intersects with money laundering and financial crime. The first is in relation to the Star Entertainment Group. You'll be aware there we took action against 11 former directors and officers of Star Entertainment Group. Two of those officers admitted breaching their directors' duties in relation to money laundering related matters, and judgment is pending in relation to 9 other former directors and officers. The trial of that matter concluded in May of this year. Another example is the Prospero Markets matter. Here, ASIC took action as part of the AFP's Operation Nightwolf in connection with a multi-billion-dollar money laundering scheme which utilised companies that had Australian financial services licences. ASIC brought court proceedings against Prospero for winding up on just and equitable grounds and cancelled Prospero's licence, which assisted in disrupting the scheme and preserving over 19 million in client monies. We have worked in relation to anti-scams, particularly in relation to the bank, both compliance actions listed in some of our reports, reports 761 and 790. We've also taken court action for failures to adequately protect consumers from scams in contravention of law. An example of that is our current civil penalty proceedings against HSBC. I might just finish with one further matter, but we're happy to provide more information to the committee, but this is an investigation and criminal proceedings against Australian actors involved in an international crime syndicate facilitating crypto asset scams. The ASIC outcomes in this matter, or ASIC's work in this matter, is continuing, but to date we've got criminal charges being laid in March of this year against Mr Gunn for dealing with suspected proceeds of crime, and then we have ASIC's licensing team has utilised interagency intelligence to disrupt an attempt by an Australian company associated with the syndicate to obtain an Australian financial services licensee that could have given that company apparent legitimacy to potential investors.
Thank you for that. Can I just send my final question to ASIC at this stage is, what lessons did the agency take from the recent CBA and Westpac money laundering breaches?
Chair, I think there are a number of lessons. Obviously, AUSTRAC will be able to speak in more detail to the court actions and outcomes it achieved there. We worked closely with AUSTRAC in relation to examining the conduct of directors and officers, both of CBA and Westpac, as we have done in relation to some of the casino matters. I mentioned the Star Casino matter. There was also the Crown Resorts matter. Our role is, as I said, sort of secondary. We're not the primary money laundering or AML, anti-money laundering regulator. AUSTRAC does that, but we do have a significant support role. A key message that, or lesson that comes from that, is the importance of large institutions such as CBA and Westpac having strong AML controls, and we will continue to investigate, supervise, investigate and take action where we see directors or officers of those organisations falling short.
So yes, I understand that AUSTRAC was the agency that laid the charges, but ASIC's role at the conclusion of that, do you investigate whether there's been breaches by directors of their licence conditions? Is that something would automatically happen under these types of circumstances?
In those matters, Chair, we investigated the directors and officers in relation to the roles that they played. I will need to take on notice where it's been some time now, so I've forgotten since those matters were concluded. My recollection is that it resulted in no action being taken by ASIC. We need to demonstrate that the director and officer has breached the relevant duty to the company in large banking organisations and other large organisations that can be challenging at times where accountability or responsibility is diffuse. It's difficult to locate a single individual within such a large entity with all the necessary elements to prove a breach of directors' duties. Since that time, the financial accountability regime has been introduced. We jointly regulate and enforce the financial accountability regime with APRA, the prudential regulator, and that has now enhanced our ability to pursue individuals where there is clearer lines of accountability.
That surely is concern that just because you're a big organisation with a lot of employees and you make a breach, that it's too difficult to identify someone to take responsibility for that. So is there more work being done to ensure that those people are responsible or held accountable?
I don't think it's a lack of willingness at all on the part of ASIC to pursue individuals and hold individuals to account. I think it's the operation of the law and by the facts. It is difficult where, as I said, accountability or responsibility is diffuse. So we see that as being largely addressed through the reforms that were introduced to implement the financial accountability regime.
So why did ASIC not release a public statement at the conclusion of its investigations into the CBA and Westpac breaches, explaining its decision not to take any enforcement action against the banks?
Chair, I'll need to take that on notice. We ordinarily inform the people that are the subject of the investigation, and we don't constrain their ability to pass that information on. But given we are exercising serious coercive powers, including the ability to bring people in and answer our questions without the right to silence, there is a public interest in ensuring that our investigations and the contents of those investigations remain confidential, particularly in circumstances where ASIC has reached a view that it is unable to take action.
I appreciate that, and if you can add to that on taking that notice on question, we'd appreciate any further detail you can give to us, and we need that by the 9th of December. Thank you very much. Just a couple of quick questions to Treasury in relation to in the ATO submission, I noted that Treasury had not been reviewing the taxation secrecy framework, which could possibly increase the ATO's information disclosure powers. Were any changes made, and if so, have those changes improved the ability of the ATO to address suspected money laundering?
Yeah, Chair, I can take that one. Thanks for the question. It relates to my answer earlier, where I sort of talked about our review and some of the further exceptions that we were looking into. So the status of that review is that we have provided advice on the outcomes of the consultation to the government, and so it's now with the government for consideration.
If you can give us any more detail on notice, that would be appreciative.
Yeah, happy to.
So, what was the role in designing Treasurer's role, as well as the AT's role, in designing the scams protection framework?
So the Treasury are the lead policy agency responsible for development of the Scams Prevention Framework Act. So we have policy responsibility for that and the subordinate instruments.
Well, how will that help combat money laundering?
So the Scams Prevention Framework is focused on taking an ecosystem-wide approach to thinking about scams. So we have regulated entities that are going to come in under the framework, and the government has announced that that will be, in the first instance, banks, telecommunications and certain digital platforms. And so the design is to sort of, expand how the government is responding to scams, asking these kind of entities to take preventative or reasonable steps to try and prevent scams. So that it's envisaged that that will complement, the work that's going on the law enforcement side in relation to scams and combating financial crime. And we expect that the SPF will interact closely with existing frameworks such as the AML-CTF regime and other arrangements to make sure that we are taking a holistic approach to try and make Australia a harder target.
But are there any duplications by having the two frameworks?
So I think the frameworks are our framework is still being developed, so the subordinate instruments that we're working on, particularly in the banking space where it might have interaction with the AML-CTF regime, but we envisage that they'll work holistically together, and we are trying to leverage what is existing in that system to avoid potential duplication risks. But I might just check if you want to add to that.
No, I think that's reasonable. So, they do serve slightly different purposes. The banks have said to us that there will be some interaction between the two, but as Lauren indicated, as we develop, so we are working on the subordinate instruments kind of essentially almost as we speak. They'll be put in place. The intention is over the next probably 9 months. And as we develop those, we will work closely, with Home Affairs and AUSTRAC to kind of consider what are the interactions with the AML CTF framework to see where there are interactions, particularly with that framework.
Well, thank you very much. Appreciate your time today and the submissions and working together to combat this growing crime. So thank you very much, and we will take a break and come back at 11:50 with our next witnesses.
Thank you.
Thank you, everyone. Group of witnesses to come forward, please. Good morning, everyone. Hands up already. I now welcome officials from AUSTRAC, Australian Federal Police and the Department of Home Affairs. And I understand that information on parliamentary privilege and the protection of witnesses giving evidence to parliamentary committees has been provided to you all. For the Hansard record, will you each please state your full name and capacity in which you're appearing today?
Tony Smith, Assistant Commissioner from Australian Border Force.
Alex Engel, Assistant Secretary Transnational Crime, Department of Home Affairs.
Ian McCartney, Deputy Commissioner of Crime in Australian Federal Police.
Brett James, Commander of Investigations, Eastern Command, Australian Federal Police.
John Moss, Deputy CEO Intelligence at AUSTRAC.
Anthony Helmond, National Manager, Law Enforcement Branch at AUSTRAC.
Thank you all for appearing before us. Do each of you want to make a few opening comments? No? AUSTRAC? No? Okay, fine. Thank you. Again, thank you from the outset for the work that you do each and every day in the interest of all Australians. Might start off with AUSTRAC. The Minister for Home Affairs announced on the 15th of October that AUSTRAC would have the power to restrict certain high-risk financial products, services and delivery channels, including crypto ATMs. How will this work in practice and what problems will it solve?
To start, Senator, the challenge of money laundering through cryptocurrency, DCs, money remitters, bullion dealers is ongoing and is noted in the National Risk Assessment on Money Laundering. The framework for how that announcement by the Minister would occur has yet to be determined, and I could hand to my colleague from Home Affairs who's working on that question.
Thanks, Chair. As you mentioned, it is looking to give a power to the CEO of AUSTRAC to look at high-risk channels. So we're currently in the design phase of that legislation, but the intention is to bring it in as soon as we can next year. And we'll also be doing some industry consultation as a part of that, just to make sure that we design it in the correct way. Essentially, we are looking at certain channels and products that, despite AML-CTF regulation, might just have such significant risks that we, even with AML anti-money laundering controls in place, there's still too a high risk there, and that it could just be being used predominantly for criminal activity. So that's the sort of policy intent behind. We're still in the drafting stage about how exactly we'll design that power for the AUSTRAC CEO, but it's likely that he'll have to take into account, a range of considerations before he uses that power, rather than just using it for any channel or any product. There's likely to be a range of criteria he'll need to take into account.
And how long before that modelling has been done?
Yeah, so we are looking to bring that in autumn next year to the parliamentary sittings, pending, drafting and consultation with industry.
In relation to AUSTRAC, and you regulate the finance and gambling institutions for compliance with the Anti-Money Laundering Act, there's been a large-scale breaches of that regime by the CBA, the Westpac, NAB, Crown Casino and Star Entertainment. How does AUSTRAC identify and mitigate selective reporting by entities?
So our regulatory priorities are set around helping those reporting entities meet their AML objectives and protect the community. In the context of the new reform and the Tranche 2 work and the agency transformation, we have some sector-based activity work where we're currently working at DCEs and VASPs. We have some obligation-based effort around SMR reporting and meeting their legal requirements. And there are some channel based approaches around REs that are exposed to cash-intensive activity. There's a range of ways to detect. So inside the FIU, we have the ability to work with law enforcement and see patterns and trends and what's been observed by the responders on the ground, and we can build typologies and case studies from those. We can also detect in our own holdings using charting and graphing anomalies and report and refer to law enforcement or our own enforcement teams. The regulatory compliance areas detect anomalies and report to our enforcement teams. Of course, some REs also self-disclose, and some of the ones you mentioned we work in collaboration with REs to identify anomalies in their AML programs and non-reporting.
So in relation to the CBA and Westpac, has anything been learnt so that the necessary mechanisms need to be put in place to ensure that doesn't happen again, and the fact that evidence from the former witness was that it wasn't easy to identify whether any director should be held responsible for those breaches. So what sort of work has AUSTRAC done in relation to the necessary changes, any mechanisms that need to be put in place to prevent that from happening again?
Enforcement action, in addition to the outcomes from the court, created deterrent for the sectors that are involved. So we see a noticeable change in controls and behaviours from reporting entities in the sectors where we've taken action. We also have tailored programs in both the regulatory and compliance teams to look for similar activity. We also have in the FIU a range of guidance supplied back to REs to help them report in a more comprehensive and correct manner. One of the initiatives coming out of the Fintel Alliance, building on those experiences, is to deconstruct typologies, write them into bank language and produce financial crime guides so banks can hardwire the codes into the algorithms to report to AUSTRAC. And of course the compliance teams have a range of indicators and red flags that can now be searched for in future compliance activity.
With Tranche 2 being implemented, has AUSTRAC recruited additional staff to assist with that transition?
Yes, in the 24-25 budget, the government announced a $166 million investment to support reforms to the AML CTF regime, and from that we are receiving $160.7 million. After the indexation and saving measures, it's $159 million for AUSTRAC over 2 years. We've recruited in the last financial year 91 new staff, and by the end of this financial year it will be a growth of 257 staff, mainly in the compliance enforcement in the regulatory areas, but also there is growth in Fintel Alliance and the FIU. There is growth in the technology and ICT and growth around how we deliver reform. There's a lot of work being done around outreach and engagement with the Tranche 2 entities at the moment, and the first people we recruited were for the outreach, and the contact centre will grow as well. So we're preparing a whole range of, the rules have been published, the guidance is due in January for the Tranche 2 entities. Those people are also working on starter packs, so Tranche 2 entities will have a starting point for the more straightforward, less complex small businesses so they can achieve their obligations easily. That's what the people are focused on at the moment.
Now, bearing in mind that we have to bed these changes down and it will create more work for AUSTRAC, Transparency International Australia, in their submission and then in given evidence, highlighted that AUSTRAC only collects data from a small subset of entities that are being used to commit or facilitate financially motivated crime and money laundering. For example, import-export business and sellers and traders of high-volume goods, high-value goods, such as luxury cars, boats, property development, cash intensive legitimate businesses. If you were to add in there art dealers, jewellers, people who sell luxury items like handbags, watches, those sort of things. Is that something that you believe that can be done? And obviously it would come under AUSTRAC, but that would again put a lot of obligations on those entities to report. Do you think that could well be, I mean, obviously it's got to be government policy, part of the next trench of changes? Because if you now have accountants and lawyers and organised crime, people who money launder, will be looking for other avenues to wash their money through. Have you got any views on that?
I do, Senator. I'm also sure my colleagues from Home Affairs would talk to this as well. The FATF recommendations are risk-based, and they cover what is in Tranche 1 and Tranche 2, and that's what the legislation has been designed to cover. We've got 17,000 entities reporting to AUSTRAC at the moment. When Tranche 2 comes on board on 1 July, that will raise to about 100,000 entities reporting. It's not just the reporting that comes through the entities. We also collect commercial data from other government agencies and international partners to add to that. I think the Tranche 1 and Tranche 2 is where I focus at the moment. As for the next change to AML-CTF, I'll leave that for Home Affairs to comment on.
Would you like to make some comments?
Yeah, so I think colleague from AUSTRAC, Mr. Moss, he's right in the sense that the FATF, that's the international global body that sets the standards, will look at internationally where the highest risks are. So that's what we've currently got covered under the regime. It was a big driver for those Tranche 2 reforms. AUSTRAC's now going from 17,000 to well over 100,000 entities. I think we calculated that it was a roughly about 192% increase in the economic activity that is covered in the economy, from which people could be putting, dirty cash through the system. So that's one element that we look at. I think in the regulatory regime as well, we're also looking at what's practical with the regulatory balance between what is useful from an intel and law enforcement point of view versus the regulation that we're putting on the economy and industry. So we have to balance, I guess, the scope of the regime about how many entities that we're covering. I think there's also a split that might need to look at, particularly with the luxury goods, between sometimes it is used for moving value and money laundering purposes, but sometimes it's actually just criminals enjoying the proceeds of their crime. So they're not necessarily looking to launder or shift value. They are just enjoying expensive things from their ill-gotten gains. And so we do have the Proceeds of Crime Act and a lot of work by the AFP to actually go after some of those goods as well. So there's a couple of elements that we can look at it, but it is a balance between having the civil regulatory regime cover the highest risk areas, but balancing that against how much regulation is across the economy. We think with Tranche 1 and Tranche 2, we've got the main gatekeepers to the economy, and that's what the design of those reforms were for.
Thank you. To the AFP, this inquiry really is about the capabilities of law enforcement, and we've asked various witnesses what their challenges are in combating money laundering, organised crime, and I just wonder if you would be able to give us some detail in relation to the challenges that the AFP face when identifying and combating money laundering and financial crime, because as we know, there are no borders anymore. It's a global issue, and this committee is well aware of the international relationships that the AFP have and other agencies. But what are the challenges for the AFP?
Yeah, thanks, Chair. So just stepping back, I mean, when we look at money laundering from an AFP perspective, it's incredibly important, the work that we do in this space, because we see it as a key facilitator for crime, particularly organised crime. So the strategies we've designed within the AFP is very much focused on money laundering as a vector, and there's two key strategies. The work that we do through the CAC, the Commonwealth Criminal Assets Confiscation Task Force, that we've spoken at length with this committee. But the second strategy is around the dedicated money laundering teams that we've set up in the AFP to target professional money laundering syndicates. And I think that's one of the, going to your question, Chair, that's one of the key challenges. We're dealing with very sophisticated organised crime syndicates that utilise a range of strategies to move both the proceeds and the instrument of crime, both internally within Australia and offshore. I think another challenge that we face at the minute across all our crime types is obviously technology. And again, as technology changes, and I think cryptocurrency has become a threat vector, but obviously working with the Department of Home Affairs, the introduction of legislation last year to allow the AFP to better target, better restrain and confiscate value of cryptocurrency, I think has been hugely beneficial in this space. So I think the sophistication, the professionalisation of these syndicates, and I think technology continues to be a key driver in terms of some of those challenges. But I think the committee should have a degree of confidence in terms of how well we work in with our Commonwealth agencies. But also it's a very collaborative relationship that we have with our state and territory partners too, Chair.
Yes, thank you for that. In terms of the capabilities, there's evidence been given that there's a real challenge for police forces, the state, AFP, for recruitment and retention, and some of the issues and suggestions of things that can be done to assist in recruitment and retention. At the moment, how many full-time staff do you have, and is there a hole in being able to recruit, and are we understaffed at the moment in terms of having the expertise? As you said, technology is so fast-moving, but yet so incredibly important. Then you have AI on top of that. Is there a shortfall in the capacity to move into this area with expertise?
So what I would say in terms of, responding to some of those challenges, we have developed internal capability within the AFP, and I think we've taken the lead working with our state and territory partners, particularly around cryptocurrency. So within the Criminal Assets Confiscation Task Force, we've set up a dedicated cryptocurrency capability that we, in terms of getting a better understanding of some of the challenges around cryptocurrency and looking at strategies, and that's an issue we share with our state and territory partners, but also we work very closely with our Five Eye partners in terms of what's happening overseas, particularly in America and the UK. I think, I'm sitting here, if the Commissioner's sitting here, if you asked us the same question, would you like more resources? You know what our response would be, Chair.
Just so you know, every agency's answered the question the same way.
So I think it's about how we slice and dice that, and how we focus on how we identify what those challenges are and how we respond to it. So obviously that cryptocurrency capability, but also the work. We've got 24 forensic accountants that are highly skilled in terms of this work that we do within AFP, and we allocate those resources around. It's also about I suppose it's the training, the base of our base investigators, particularly around technology and money laundering and proceeds of crime. We invest heavily in that in terms of on-the-job training in relation to those officers. So I think we have responded to the change in the environment in terms of building new capability.
Is there effective coordination mechanisms in place for the Commonwealth agencies to discuss money laundering and financial crime issues? And And is there a regular basis for this interaction? And are there task force? I mean, we know you all work together very closely, but money laundering is only one part of all the crimes that the AFP look at.
Yeah, so I said at the start, there's really two key strategies that we have, overarching strategies. One is around proceeds of crime, and through the Commonwealth Criminal Assets Confiscation Task Force, which is a Commonwealth task force. We work very closely with every agency here represented. They're members of that task force, so it's a very cooperative and collaborative arrangement. In terms of proceeds, the AFP leads a working group with our state and territory partners in terms of trends, analysis, how we can better work together across Australia. And then obviously through our work with the Criminal Assets Confiscation Task Force, we take a leading role, particularly in Asia, through the Karen network in terms of working with over 40 countries in Asia and the Pacific in terms of how we coordinate and collaborate regionally. In terms of money laundering, there's a range of mechanisms in place. Obviously, the Serious and Organised Crime Coordination Committee that we work with at the Assistant Commissioner level with our state and territory partners. The work that they do, particularly focused on organised crime, money laundering is a key threat, not just for us, but for state and territory police too. So the work that we do in terms of that arrangement, but also our joint organised crime task force arrangements, I think the committee should have some confidence that those are robust, mature and effective arrangements.
So do you think that the existing laws are sufficient to combat money laundering and financial crime, or are there still legislative changes that are needed?
I've noted the legislative reform around cryptocurrency, and again, it's that identification that the environment's changed, and therefore, from our perspective, at that broad level, the legislation needed to keep pace with technological changes, and again, well supported by Home Affairs. I think as I think my colleagues from Home Affairs would indicate, we are very proactive in terms of once we identify the requirement for legislative reform for us to do our job more effectively and efficiently, we do engage, and the department are very receptive. There's some work that's ongoing at the minute. I might pass to my colleague just in terms of particularly around the proceeds regime. Alex, I don't know whether you want to jump in.
Yeah, thank you. As DC McCartney has mentioned, we obviously take advice from our operational agencies, whether it's from ABF on that side through to the financial intelligence side and the various law enforcement agencies. We do work closely on trying to figure out what are the emerging new threats, so whether that's from ACIC providing us with new intel or operational challenges that they may be facing. Obviously, we have to factor that into legislative program, space for that in the Parliament. Can we make the changes? Part of that work, obviously, the AML-CTF reforms was a large one in this space that we've done over the last term of government and now moving into the implementation phase. It's created a bit of a space for us now to think about other elements of the regime, so that'll be around proceeds of crime. So we do work closely. AFP let us know, the regime could be more efficient in this way and that way, and then we work through those problems. Ultimately, we'll take that to government, so nothing at this point in time, but we do have ongoing conversations, rather than leaving it for a crisis.
I'll go to
Thank you.
To Dan.
Thank you, Chair. While we're with Waterforce, I'll have a quick chat with you guys. So money laundering is obviously a huge thing in this country and all around the world. And obviously it is funding a lot of the things that are coming into our country, being imported in. For instance, drugs and tobacco. How are we getting on top of what they are actually bringing into this country right now? What are we working with right now?
Certainly, in respect to tackling illicit tobacco and in terms of border control drugs, the increased numbers at the borders, we've increased the number of detections and seizures of border control drugs, and certainly on illicit tobacco over the last financial year, we've seen about a 38% increase in the number of illicit cigarettes that were seized at the border, which worked out to around 23,000 detections, 2.5 billion cigarettes themselves that were detected. So our numbers are certainly increasing from that perspective. That link across to financial crime and money laundering, it comes back to the point in relation to collaboration. So we are, as my colleagues have mentioned before, support the Criminal Assets Confiscation Task Force within the AFP, and we're funded underneath that recent hunting licence to enable us to have resources that support financial investigations for the CACT. But on a day-to-day basis, the Illicit Tobacco Task Force, which was commenced in 2018, is also partnered with AUSTRAC, where we work side by side alongside ACIC as well, to be able to use the capabilities of those agencies to identify financial crime within those commodities of illicit tobacco. Border controlled drugs investigations, once seized at the border, are then a matter for the AFP in terms of formal investigations, but we continue to provide that level of support as required.
And with you having seized 2.5 billion cigarettes, that is a lot. And congratulations on having these seizures and having more. Are we seeing more seizures because there's more being imported into the country? Or are we seeing more seizures because you guys are doing fantastic work as well?
Yeah, I think it's fair to say it would be both. Yep. I think it's when we look at our efforts and accelerated efforts, we were funded to increase our numbers in terms of our presence at the border, but also taking that fight offshore. So we've increased our numbers of liaison officers in key transshipment countries around the world, which has enabled us to have offshore partners to provide information about potential illicit cigarette seizures at the border. So we've seen an accelerated effort which has seen the increase in cigarettes. Certainly the Illicit Tobacco and E-Cigarette Commissioner has a much more holistic view across the network from both domestic and international to provide that précis in terms of the impact that we're having at the border. But you're right, in terms of what we're seeing at the border has increased, and I think what we're seeing domestically has increased as well.
And what help would you need to seize more? What can we do best from this building to help you guys out there on the docks where all the shipments are coming in? What can we do to help best?
Yeah, certainly the government's done a lot to help us to date. Certainly the funding packages that we've received have enabled us to increase resources and technologies. It's really coming down to collaboration more than anything else. So we have a very strong partnership across our Commonwealth, state and territory partners working in joint operations across the country. And that's strengthened purely on the basis of our ability to see illicit tobacco as a key target for all of us and a key priority for all agencies at the same time. So I think that it's fair to say that the funding resources that we've been given by government have been put to good use, and that is supporting us in terms of moving forward.
Yeah, good stuff. And it's good to hear that you're getting the states and territories on board with this and working towards this. This is probably more to the AFP now. How well are the states and territories working across this whole sector, not just with illegal tobacco, but all areas of money laundering? How is the system working? Because it's not always ideal sometimes.
It works though. I mean, federation's an interesting space at times, but it does work. And again, there's a degree of relationships that have been built up for many years. So I think in terms of the approach from state police, and I use tobacco as an example, there is a focus from state police in relation to the tobacco issue at the minute, because it is directly impacted in terms of some of the organised crime threats they have in their states and territories. And just leading on from my colleague from Border Force, we have received funding from government. We received, at the start of this financial year, $33 million. Now, $17 million of that we've allocated to the states and territories for them to work with us. So $33 million. Over the last 5 months, we've restrained over $33 million in assets linked to the illicit tobacco trade. And in one case, it was $22 million. So even with that funding, we're starting to reap significant benefits in relation to this issue. I think that's a really good example in terms of how we've worked with the states and territories. The AFP receiving money, but some of that money has been allocated to the states and territories to help them in terms of targeting illicit funds coming out of the tobacco trade.
And it's definitely understandable to see why our local police
Yep.
find it hard to be able to get to all these places and do things with all the other things they've got to do,
Yep.
like the domestic violence,
Yep.
the other issues that they're dealing with all around our local areas. So to get $33 million worth of assets that you guys have done a great job there and work with the states and territories. What more can we all do to turn that $33 million into $133 million and really see us start to pull this back and not have every second shop in Cessnock as a tobacconist?
That $33 million will increase. I mean, we're only 5 months into this financial year. The funding, that $33 million is actually over 2 years, so I'm confident to say we'll well exceed that. I think the issue of illicit tobacco, I think targeting the illicit, in terms of targeting the illicit funds that emanate from this trade is really important. But it's that in itself is not the panacea, and I think we've discussed before this committee in terms of a systems approach. So there's a range of strategies and initiatives underway, led by the Tobacco Commissioner in terms of working with Commonwealth agencies, but also working with state and territory police agencies from enforcement, from storage of this material, from increased support. So I think. Time will tell, but we see, and this is a good example where the strategies we've put in place over the last five months are starting to bite.
Yep, excellent. And so away from that now and just back to normal money laundering.
Yep.
How the technology is getting better and better with the criminals, and we always seem to be a step behind.
Yep.
How do we actually get that one step in front where we're being proactive instead of reactive to a situation?
Yeah, so I think intelligence-led policing, I think if we go back to the cryptocurrency again, it's a lot easier in the movies sometimes, I think, in terms of some of these issues, but I think we have been proactive once we identified cryptocurrency as a new vector for state and territory police, for criminals to move their illicit funds. We've worked closely with the Department of Home Affairs and will continue to do that. I think intelligence-led policing, I think it's important, the quality of the intelligence we receive. We're very supportive of Tranche 2 in terms of that additional intelligence that AUSTRAC will receive. I think just a shout out to AUSTRAC, I think we're very lucky here to have in Australia, to have an agency like AUSTRAC. As I get the chance to speak to my colleagues overseas, we're so well placed in terms of the quality of intelligence that we do receive from AUSTRAC. And I think the additional intelligence we'll receive from Tranche 2 in terms of those new sectors will add to our understanding of what the environment is and allow us to be more proactive in terms of operationally, but also more proactive if we need legislative reform.
I think just to add to that, particularly on the crypto element, I think with Tranche 2, people will focus on the real estate agents, accountants and lawyers. But within that, Australia already covered some elements of digital currency or cryptocurrency, which was the cash into crypto and crypto back out of the system. But there's a huge ecosystem within it where we're trying to make the regime more technology agnostic. So there's the old way that banks do things, the way that cryptocurrency operates is a different technology underneath. But what we're going for is how is value moved through the system. So under the Tranche 2 reforms, we'll now fully cover cryptocurrency, so what's happening inside the exchanges back and forth, not just from the cash into crypto and back out again. So that will, I think as DC McCartney mentioned, that'll then supply greater information through to AUSTRAC, through the intelligence side, then through to law enforcement. So yeah, Tranche 2 is big on the lawyers, accountants, real estate agents, but it is now fully going to cover the cryptocurrency space.
Good stuff. Just as you said, a shout out to AUSTRAC, like a shout out to all of you, honestly, and everybody else that's given evidence here today, because you're all doing your best to keep us as safe as possible, and I think you guys need to be applauded for that, for the hard work that you all put in that most people don't see behind the scenes. So keep up the great work, and glad you brought up with the Tranche 2 that the changes in here will make a big difference. From that, the changes there, what more can we do? What more do we need to look at as government to be able to make bigger differences in this space where you can all work together a hell of a lot better? You're doing a good job now, but to make it even better again, what are the things that we can do? Because this is what this needs to flush out, really, so that we can go to government and speak to them to really make sure that we are making sure that you guys have got the best tools available to you from us as well. And go to town on this, don't be afraid. It's a safe space.
I was going to say, sitting in the department looking after the policy and legislation side, obviously we'll provide that advice up to the minister, but we would take the advice from our operational agencies about the changing threat environment, what new gaps are emerging, as we move to do things like Tranche 2, where are the CRIMs going to move to, where are they going to innovate. So we look to our operational agencies to understand what those changes are, and then is policy and legislation needed changes there. I think the other thing that we think about a lot, which I think I've heard earlier today in the committee, is that it's there's always going to be an element of investigations, arrests and prosecutions, but it's this, I think, as DC McCartney's mentioned, a systems approach. So we need to look at the private sector is the gatekeeper to a lot of this, so how do we work with them? That's through the civil regulation. How does that then produce intelligence? How much of this do you disrupt and prevent before it actually occurs? And then, of course, you then move through to the more harder-edged law enforcement actions. But I'd probably leave it to my colleagues to talk about the threats that they're seeing.
Yeah, I think if we had sat here a little while back where we said we need Tranche 2, and we've now got Tranche 2, and I think that's going to be extremely beneficial for us in terms of particularly that additional financial intelligence we'll receive, and particularly focused on those key vectors. I think we just, and again, intelligence will be key to us understanding the environment. Technology is changing so fast. I think we've a little bit behind cryptocurrency. We've now caught up, but I think is the environment. If we come back in 6 months' time, I think the environment will change from a technology perspective. So it's intelligence is crucial. So in terms of, I suppose you're asking us what we need from the AFP. We need Tranche 2 fully implemented and up and running. And again, we've offered our support, and we're working very closely with AUSTRAC and the department in relation to that issue.
We're not going to be ahead of the criminal use of technology. They will deploy it earlier than us in ways that ignores privacy, legislative frameworks, cost and return on investment. But what we can do is close the gap. So the work that we're doing around crypto with partners, including in AUSTRAC with the Crypto Task Force, and responding with legislative and law enforcement disruption helps. The work we're doing with the private sector, who often has better technology than the government, in things like the FinTel Alliance, our public-private partnership, allows us to come up with new innovative ways to share data and find cross-jurisdictional, cross-institutional activity, which is where the criminals hide financial crime. And I also think the adoption of AI, so we're starting to see user cases demonstrated across law enforcement. We certainly have trials and pilots in AUSTRAC, and we've been working with the banks to understand how they deploy AI in their business model to combat money laundering and terrorism financing. If you're asking for 3 short, quick things that could be achieved, and maybe they're not quick, I think beneficial ownership is a big gap. And not just beneficial ownership register, but one that has verified data that can be used in all our agencies. I think at some point we will have to glue together all the different initiatives around financial crime that exist. So some form of economic crime strategy that glues together the work we do in sanctions, fraud, money laundering, and other financial crime and volume crime. And I also think, for my own agency, the lack of access to the criminal intelligence databases holds us back. Modern systems that use AI and advanced analytics need the inputs to detect the anomalies for actionable referrals to law enforcement. There are 500,000 reports coming to AUSTRAC every day. To work out the ones that are important to work up and refer to law enforcement or to a private sector public environment, we need the context of the entities, the addresses, the phone numbers. We don't have that today.
Can I ask on that, why don't you have access to that, considering you guys are the most intelligent, like the best intelligence gathering people in this whole country?
I think it's a complex answer. The information is held is not owned by any one entity, and it requires consensus amongst the policing agencies to share it. And the systems, I think, have yet to evolve to a place where there is trust in allowing a broader population to use them.
Would you say that so if you could get more access to these systems, which are all government systems already and held by government agencies, you would be able to do your job more effectively and ultimately make this a safer environment for everybody?
It would be a game changer in the technology sense. We have workarounds at the moment by working in task forces, embedding people into other agencies and having different MOUs to share for particular purposes. But if there was more information flowing between tax, law enforcement, ACIC, state and territory in a way that was easily digestible into modern systems that use charting and graphing to find anomalies, that's what the private sector is doing today.
Yep. Okay. We heard evidence from some witnesses earlier that there is exceptions that are working well in this space, as you've just said there. Do we need to have big changes, big legislative changes there to give you access and you guys access into other areas to make the best use of taxpayers' money for starters, and to be then able to arrest more people through not only money laundering but all of the other things that are issues in this country?
I'm not sure it's a legislative issue.
Okay.
I mean, picking up on some of this, I think when we look at, it's even just not even the money laundering. So if you look at financial crime or economic crime across the system.
Crime in general, yeah.
Yeah, we're looking at transnational serious organised crime actors. There are specific crime types here. It's the import of the illicit tobacco, it's the drugs, it's et cetera, et cetera. So we've got particular crime types that we're looking at. But then you need to, I guess, think about it as a network or an organisation. So how do you actually go about going after the network and the connectors that they have? So one of them is we go after the money, but even in the money space, there's different crime types, you know, scams versus money laundering versus fraud versus identity, cybercrime, and so on. So it's something for us to think about in terms of how we organise across the legislative frameworks. So they've all been designed around specific crime types in a way. So yeah, there is probably a piece there about how we organise better across the TSOC networks and how do we bring to bear those existing legislative frameworks against those issues that look at the network as a whole rather than, you're still going to look at those crime types, but how do you go after the enablers of those networks? So that's going after the money. Another element of that is the communications piece as well. So government's looking at electronic surveillance reform, so that's the powers that law enforcement and intel agencies can use, so that's going after the connector of their communications, and then also looking at new legislation for the Australian Criminal Intelligence Commission, so that's about making them into a fully fledged intel agency for criminal intelligence as well. So there's crime type, but then there's also how do you look at the network and how they function as a phenomenon, and how do you go after how they operate as a network rather than specific crime types.
But can I just ask? Sure. Every agency that's come before us always talk about how well everyone works together. Yeah. And obviously you do, because if you don't, we're not going to overcome crime, let alone money laundering. But surely with all the task force that are set up to communicate between all the lead agencies, there's got to be a way of prioritising what is the most important crime that we're dealing with at the moment, and at least try to allow access at a high level. Obviously, you can't have every police officer in the country accessing all this information, or everyone necessarily at AUSTRAC, but surely in the conversations over a long period of time, that can be achieved. We don't want to be sitting here, well, I won't be sitting here in 30 years, I can assure you, but if you look at what happened with the National Gun Register, like 30 years after Port Arthur. It's appalling that it's taken that long. And even though it happened in Tasmania, Tasmanian police force is still using paper. registration of firearms. So if there's a real will, there will be a way to be able to access that information, because after all, you're all working for the Australian people, trying to keep them safe. And all this illegal activity, money laundering, cybercrime is taking billions and billions of dollars out of the Australian economy and doing so much harm. Sorry.
So just to answer that, and bring some positive aspects to the table, I'm sure if we walked out of here and we asked a member of the public, does policing and state police have one database that we all share and we all connect to? The answer is no, we don't. We operate off different systems. And really what it does come down to is leadership and culture. So there's credit due to particularly in terms of the commissioners, the NCIS, the national database that the ACIC now run, the ability for us to share information amongst state and territory police has really been of assistance and will be even more of assistance into the future. I think one of the other issues there's the cultural issue, there's the legislative reform, and then there's the infrastructure, which I think is improving. But the issue for us is the volume of data that we're now seizing, and we're now the ability for us to share. We used to go out and do a search warrant and seize some cabinets with documents in it. We're now seizing data at levels that are exponentially increasing as year on year goes by. So I think my colleagues mentioned AI. Now, AI is a significant threat to the criminal environment. I don't think we've fully grasped what that impact actually is, but there's a clear recognition, particularly from an AFP and the other state and territory police forces, that we actually need to use AI in terms of some of the strategies we've put in place. Obviously, with responsibility comes responsibility, and the need for us to be proportionate, justified, transparent. And I'm sure Chair will come back before this committee in terms of how we're using AI. So again, we can, and I get your point, we can be critical, but I think particularly there's some positive green shoots, and there's been a lot of work done to actually improve the system moving forward.
Sorry, you have to call.
Sorry, it's all right, Chair. With AI, and I'm glad that you've brought that up, and it's been brought up a couple of times now, what is holding us back from using AI more in these systems at a more high level to get to where we get to? Because we know how critical this is to get to where we need to be, A, for workforce shortages, B, because it can go through and do a lot of the work that takes up a hell of a lot of time from everybody that works in your organisations. Why are we so slow at getting on top of that and getting into that field when we already have crims doing it?
Well, I think we need to be proportionate, justified, transparent. So there's a lot of work that's been done over the last couple of years, particularly through the ANSPA protocol, so that all of the police agencies, and the AFP has taken a leading role in this, in terms of all of the policing agencies in Australia have signed off on key principles in terms of how they're going to utilise AI, because otherwise you run the risk of our officers going off and, choosing software that doesn't fit within those protocols. So again, it's taken time to get us to this stage. I think now is the time for us to implement some of those strategies. So I think you've met the new commissioner of the AFP. One of her 5 priorities, and a key priority for her role as the commissioner is enhancing the use of technology in the AFP, and AI and how we utilise AI will be instrumental in relation to that. So I think, I don't think we're walking yet, we're not even crawling, but I think you'll see exponential adoption within the AFP, using it responsibly in terms of the crime types that we investigate, and financial crime, online child sex exploitation, all the crime types we investigate. We must embrace AI in terms of those challenges.
I was very impressed in the new Commissioner's address to the National Press Club, as I'm sure most MPs were, to hear what she had to say and what the goal is of seeing where the AFP goes in future. And we all know that the criminals don't stick to one field when they're doing things wrong. So I find it just hard to get through my head that we'll have cybercrime here, we'll have money laundering here, we'll have this here, we'll have this here, and that they're not always so well connected. And I'm sure the general public would struggle with that in their heads as well, thinking that you guys should be able to move that information around and work with that information together with the high levels of clearance that you guys have to all work with. I think that would be a much better use of resources along the way. That's it for my questioning too.
Okay, great. I wanted to go to AUSTRAC in terms of how you're going to mitigate the risk that professionals facilitating criminal activities will spike in Trench 2 entities ahead of the AML-CTF obligations, and where you see the challenges going forward in this area for AUSTRAC.
Where are we now with Tranche 2 and reform? So to date we've published guidance for the tipping off obligations. That was done in March. We've published the new rules. That was done in August. We're now working through core and industry-specific guidance for the Tranche 2 industries and the startup programs that we talked about, which we haven't done before. Tranche 2, we didn't supply, Tranche 1, we didn't supply startup programs. It's something we've learned along the way, and it's an initiative from the CEO that we can give more guidance and support that's directly relatable to REs building their AML programs, if they have the starting point that they can then tailor to their own risk pictures. And for many of them, the starter packs will be hopefully sufficient. And that's all due in January next year, 26. In March, the Tranche 2 entities start to register and enrol. And we will have some more guidance and a framework for the private sharing by then. And then the data will flow from Tranche 2 in 1 July. Interesting, not just the AUSTRAC, our information systems, we call it Analyst Workbench, which is our system that we push information out on, is accessible by I think close to 40 other agencies, 5,000 users, and they conduct 10 million searches a year. So from 1 July, those 10 million searches will automatically be trolling, in addition to Tranche 1 reporting, the Tranche 2 reporting.
Keep going.
In addition to that, there's a lot of consultation happening with industry around co-design and co-authoring of the guidance and starter packs, so that we can understand their needs and help reduce the regulatory burden on those entities.
The Real Estate Institute appeared before us yesterday, and they said they've been working closely with your agency, but there's still some concern in relation to disclosure. From an agent who is selling a property, that's one thing, but for them, for the buyer to have the same responsibility of notification, they still see that there's a problem in that area, that they don't have that capacity to have those conversations. So I just wondered if there's still work being done on that. And secondly, the fact that they're not highly rated in the community as the most trustworthy people, real estate agents. I can't imagine why, but they're not. That they also need to have pretty plain speaking language so that real estate agents are comfortable and can understand their responsibilities that's been placed on them. So I'd just like to know what you've been doing there. And then my third element of that question is, will there be a public campaign to raise awareness about these changes so that when people are going to sell their house, they know that they're going to have to put forward certain information that they haven't had to disclose before?
We've been doing industry forums every 2 months with the new Tranche 2 entities, and we're listening to what they have to say. The issue around customer due diligence is being built into our guidance and into the starter packs to assist. And I think the outreach projects we have underway will continue to evolve. So the starter packs and the guidance, of course, will gain more nuance as we understand the complexities of these new sectors. Did you want to add to that, Anthony? Because Anthony's been working on the reform program before he was in law enforcement.
Yeah, thanks, John. So we've had industry outreach through formal industry consultation groups around developing our guidance, also just listening to feedback from industry as well. But we've really, because of the size and scale of these new industries, we've really tried to leverage the industry bodies and get our messages out to them, and so that way we can use the communication platforms that they have, the reach into their members that they have as well, to get our message through. We found that's been quite an effective mechanism. In terms of your comment around the plain language, that's when we've developed this guidance, we've certainly given it to industry bodies and leads within those sectors who have that specialist knowledge, and so they've done a lot of redrafting to really tailor the language into a communication style that will resonate with those different sectors as well. So it's quite specific depending on the sector that we're providing information for. And then in relation to broader public awareness, AUSTRAC is pushing out information through a range of different channels. We have our website, our social media channels. Our CEO is very active in a range of different media forums that he speaks at, along with the industry associations as well. So there's a few different channels that we're looking to get the message out on.
Would it be possible to table the starter packs and the guidance documents that you're providing to these industries to the committee?
We can certainly share. I mean, the legislation, the rules, and the core guidance have all been released. The starter packs and sector-specific guidance are still in draft. There are some pieces of guidance on our website which is sector-specific indicators for money laundering as well. So they've also been released.
So the answer is yes.
Great, thank you. Tipping off, can you explain to us, you're obviously aware that there's still some concerns in relation to tipping off, and what information is again shared and whether that can be used to prosecute?
So there's probably a more legal view, but they have been given guidance on tipping off recently from the AUSTRAC CEO, and the framework for how private-to-private sharing is being worked through by Home Affairs and is due soon. Maybe that's where we could start.
Yeah, so it might be helpful to talk about how tipping off used to work before these changes came into effect. So there was more of a straight prohibition on anything that we would call a suspicious matter report. That's something that a bank might put in about an individual that goes to AUSTRAC. Once that becomes AUSTRAC information, there's a straight prohibition on sharing any of it. Even within a bank structure, even though there's various parts of the bank that may have an interest, it was fairly locked down, fairly legally risk-averse way of dealing with that. There's very important reasons to do that. Part of the tipping off where it comes from is that you don't want to actually tip off the person who may be subject to an investigation to mess up what law enforcement might be doing. With our changes, we open the aperture up a little bit, but still have protections in there for law enforcement. So now the judgment for regulated entities is if they share the information in a way that is likely to prejudice an investigation. Now, AUSTRAC's working on guidance about what that actually means at a practical level. That allows for maybe freer sharing within a business group so they can prevent more money laundering or more scams or whatever it might be. Inside those organisations, we are looking at, and there was an intention with the reforms to look at private to private. So there's a range of, which Dr Moss might want to talk about, the public-private partnership, FinTel, but we do recognise that to get ahead of a lot of this, we want to head into a prevention and disruption space. A lot of the information, sophistication and the workforce is actually sitting in the private sector. So how can they share information responsibly without messing up a law enforcement investigation to actually then put those controls and preventions in place? So under the under the Act that we passed, the Parliament passed, we put in mechanisms for private-to-private sharing, but we now need to put regulations in place to figure out how to do that in a sensible way. So we have been sitting down with industry, the private sector, to think about what sort of mechanisms or structures could work in the private-to-private space, but we will be looking to put in regulations to put shape around that, to provide, on the one hand, confidence that the information is going to be shared in a sensible way. On the flip side, will give confidence to the private sector that they can share it without sort of AUSTRAC or somebody else looking over their shoulder and going after them for sharing that information. So we're trying to find that balance now in the regulations that we're developing.
I look forward to learning more about that. From the AFP's submission, you raised monies from controlled operations and that they're classified as becoming tainted proceeds of crime. But you've also been working with the Attorney General's department to address this issue and allow the reuse of these funds for future controlled operations. How's that progressing?
It's progressing well. I mean, it's a complex space, and again, it's complex enough when you're dealing with cash, but when you're dealing with cryptocurrency, and that cryptocurrency is used and continued to be used, it's created some challenges, but I think successfully working with the Attorney General's Department and the continuing work with Home Affairs, we find solutions to enable our investigators to do that work. I think one of the areas, particularly why it's so important for us, is the work that we're doing around the Avarice Task Force, but particularly in relation to professional money laundering syndicates. And I might just pass to Commander James just to highlight some of that work and how we've utilised some of the controlled operations work.
Thank you. Avarice has been. Its inception was 17th of March 2023. It's been quite successful, obviously, since that time, with just up to August this year, 233 search warrants conducted, 60 arrests, and over $413 million restrained or seized in assets and or cash. It's a really key partnership for us in the AFP in fighting money laundering. I think some of the legislation change or some of the legislation that we hold in Australia has been really valuable, particularly the fact that we don't need a predicate offence to investigate money laundering, which is quite a powerful tool, and it's a bit of an envy of some other countries around the world that don't have that. The general crime legislation that's just been passed is very handy as well in relation, and we've had some really good successes early on in relation to that legislation, and some of our investigators are now deferring to that legislation as a key piece of legislation in the disruption of money laundering. So there's been some really good advances over the last few years as part of Avarice and its involvement or its evolution over the last 3 years. Key part, obviously, is the relationships that we hold with ABF, ACIC and AUSTRAC. That partnership piece, as we've spoken about already today, is fundamental to our success. And then obviously reaching further into our international partnerships in the Five Eyes. But as far as operational success, the use of controlled operation orders are fundamental to the success of many of our operations. It helps our investigators actually infiltrate money laundering organisations. It enhances their ability to investigate. It improves our strategies and gives us more power to actually infiltrate and then obviously arrest and prosecute.
So, money laundering, many witnesses said it's really difficult to measure how much money is being washed through our country, and because of the hidden nature of the whole process. But how then can we assess, and how does the AFP reassess what strategies are actually effective, and how can you measure something that you can't measure how much money is being laundered? How can you measure what's effective in your strategies?
So I think ACIC appeared today, and I think they did some of the billion-dollar figures they're quoting in terms of what's flowing through the economy in terms of proceeds of crime.
I think may have underestimated actually.
Yeah,
so.
it's a really valid question. I think it's ensuring It's ensuring our strategies are the most effective and efficient. And again, as I said at the start, Senator, I think asset confiscation is crucial in terms of the illicit proceeds of the crime, but it's actually attacking not so much individuals involved, but the money laundering syndicates that are actually involved. These key professional money laundering syndicates that are targeting and providing the service to organised crime. And I think Commander James has touched upon the work around avarice. It's not focused on individuals; it's focused on syndicates that are facilitating this crime. I think we're being more effective in this space. I think we're creating, and again, we're not going to eradicate the problem, but we're creating, I think, an environment where it's much more hostile for these criminals to operate. But I think the starting point, and if we look at proceeds of crime, the vast majority of proceeds of crimes linked to the illicit drug trade. And unfortunately, as you're well aware, Senator, Australia has an insatiable demand for drugs in this country. And again, we've noted, I think it requires a system approach both in demand and supply, and there's a key focus on education. I think for the work that we're doing, I think we've delivered really effective and efficient strategies in some of the results in this space.
So if we turn to the incidences with the CBA and Westpac banks, my understanding is the AFP has some difficulties because of the Australian privacy principles in being restricted from access to information from these financial institutions. How can this information eventually be used, and can you elaborate to the committee the issue and how that actually is a roadblocker for the AFP being able to pursue this illegal activity, and have you got any solutions that you can advise the committee on?
I think in terms of that information exchange, it's more situated with the financial institutions in terms of their powers to share. We can seize that information under warrant, and we do. I think stepping back, I think a key issue, and again, the work that AUSTRAC's done in terms of holding some of these financial institutions to account. We have, not that I'm here to defend financial institutions, Senator, but we've seen, particularly over the last number of years, a real willingness from the major banks to work more closely with the AFP. I think it's a cultural change within AFP. We've talked a big game in terms of engaging with the sectors. We now have MOUs with all of the financial institutions. We've got very cooperative relationships where we work very closely. We second some of our members into the banks and vice versa. So we're breaking down some of those boundaries in terms of cultural boundaries. We're sharing capability. They're sharing capability with us. I think that's a journey that we continue to be on. But I think in terms of legislative fixes for information exchange, I just don't think there's a silver bullet to that one. And I think, if there is, and we find one, we'll definitely engage with the department. But I think we've seen, particularly over the last couple of years, and whether it's been because of the action that AUSTRAC's taken, we've seen an increase of financial intelligence being provided from the banks.
With the NAB submission, it reported instances where they had referred matters to the AFP in JPC 3, which had been requested that the matter be referred to state-based law enforcement financial crime unit, which has in turn requested NAB to attend a local police station to make a referral in person to a uniformed constable at the front desk. Are you aware of these things happening? Is it something that is occurring on a regular basis? And if it is, how do we address these inefficiencies?
Well, I think that if it's through the JPC3, Senator, that would link, we've been before this committee to talk about cybercrime, the volume of cybercrime in this country, and how we work collaboratively in terms of prioritisation. Some of the matters with the AFP, Some of the matters sit with state and territory police, but the volume is alarming in terms of how we respond. How we respond, you've noted at the JPC3, where I think you've had the opportunity to visit that, Senator. We actually have secondments from all of the state and territory police where they sit next to AFP officers. But importantly, we have secondees from financial institutions. I think we've got someone from the NEB that actually sits in the JPC3. So again, I get some of the complaints, but I think that mechanism we've set up at JPC to better understand in terms of how we approach some of these issues, I think that's been really beneficial.
We had a representative from the Northern Territory Police Force giving evidence as well that they now have a team of 2.
Yep.
But they've noted that there's been an increase in money laundering, in terms of cybercrime, every form. It's just happening everywhere, but it's a lot to expect 2 officers to be able to deal with that. Do they have a representative now on the JPC3?
They do. I don't know if I don't believe it's. I can take that on notice. I don't believe they second someone in there permanently, but they're part of the construct, and I think we fund one of their offices. It goes to your question, Senator. I mean, they're, our state and territory police partners are everybody's stretched. They're stretched with volume crime and DV. I think the benefit that AFP can provide, and again through the JPC3, is that capability support that we can provide through that JPC arrangement. That's intelligence exchange, but it's also training. It's also identification of some of the tools that AFP and other agencies are utilising. We can share that with the Northern Territory Police, and I think we've got a very collaborative and cooperative arrangement with that police force.
Yes, thank you for that. In relation to the Pacific Islands and our close neighbours, I know that there are AFP officers located in some of those places. What sort of work has been done in as far as educating those communities and their law enforcement in relation to money laundering and organised crime?
Yeah, unfortunately, you've seen there's been an increase in these communities, and I think we've spoken at length before this committee, and also Senate estimates about the priority focus that we now have on the Pacific in terms of capacity building, in terms of training, courses that we run in Australia focused on money laundering and proceeds of crime. We will bring in officers from those countries. I'm the co-chair of the Australian Asia Pacific Group on Money Laundering, which sits under FATF. Pacific countries are crucial, and they form a part of that. And again, a focus of that work is capacity and capability support to these countries.
Just to add to DC McCartney, so from the department's perspective, obviously they're looking at the law enforcement operations side. We will help with the FATF and the APG. We'll obviously say these are the global standards, taking into account the context of the small island states. And so we'll look at the sort of the front end, so their legal frameworks, their regulatory frameworks. So we've got a small team that assists them with getting their ledge frameworks right, so that when the operational work comes through, or when AUSTRAC also does cap building as well, they can use those. And then we have somebody in line posted into the PNG system as well to help them with some of these issues.
And from the AUSTRAC perspective, Senator, we have a liaison officer in Fiji who has a regional responsibility for helping with financial intelligence training, but we've also supplied from Australia IT systems for all the Pacific FIUs, so they can all ingest data from banks and analyse it. And we facilitate multilateral intelligence programs where analysts can come together and work on mutually agreed topics that are normally corruption or narcotics focused. And we're also moving to bring the Pacific Island countries together around regulatory standards, so we can have minimum best practice and harmonised approaches.
So what has been the response from those islands in terms of trying to bring them all together?
They're very enthusiastic, and engaged, noting that really PNG and Fiji are the only two quite large FIUs. The rest are 2, 3, 4 person organisations. The distances are large and they operate in contexts that are very complex around different banks, different definitions around corruption, different international players influencing them.
Are there many international banks operating in the South Pacific?
Yes, there are. There's some Australian banks are operating.
Besides ours?
Beside ours, yes. There's a French bank we saw recently. China has some commercial interests in PNG. Bank of South Pacific. There's a range of international banks. Not many of the big. There's no Citibank, Standard Charters, HSBCs operating. None of those big Wolfsburg type organisation banks.
Senator, if I can add to some of the comments of my colleagues, especially with the Asia Pacific region as well. Australian Border Force has a very strong focus on trade-based money laundering, and you may have seen it in the submission where we've a very strong focus around misdeclaration of goods, undervaluation of goods, and serious organised crime using the trade system as a mechanism to funnel funds offshore. Since July this year, the Australian Border Force set out what we call a Lighthouse project, which is working with the World Customs Organisation, so 187 administrations around the world, in terms of data sharing, in terms of intelligence sharing, specifically around trade-based money laundering. And specific to the Asia Pacific, we've got 18 Asia Pacific partners that are working alongside us with that trade Lighthouse project on trade-based money laundering. But that also works with that private-public partnership as well. So we work alongside the Asian Development Bank in there, as well as the our Border Five Eye partners and the World Customs Organisation and Oceanic Customs Organisation as well. But we're seeing some incredible results in the sense of opening up the access to our Asia Pacific partners, especially customs administrations, in understanding what level of money laundering potentially is occurring in their region, and then obviously helping them by having an alliance across the Asia Pacific in combating it.
Thank you for that. There's been evidence to the committee in relation to the whole issue of money laundering and the fact that, resources are directed towards those who actually have a physical presence in Australia, even though we know it's a global issue. And I was just wondering, just for the record, if the AFP and others want to make a contribution to this, that there are limitations of what you can do if someone's based overseas in terms of our authority there. So can you step us through the process of how you determine who you're going after to prosecute, and then what are the restrictions in being able to prosecute people that are involved in this organised crime and money laundering who don't live in Australia or don't have any assets here?
So in terms of who we focus on, given resource, and it's intelligence-led policing that we're focused on the highest priority. And we've been on the record that we have a range of suspects based in Australia, but more and more the suspects that we investigate are offshore. So the importance of those international relationships, and there has been cases in the past we've worked with our American colleagues in terms of successfully targeting key money laundering identities in the Middle East, and those people have been prosecuted offshore, not back in Australia. So again, it's working with our Five Eye partners. I think in a couple of weeks, Commander James is off to The Hague to work with our Five Eye partners in terms, and our European partners in terms of how we can better cooperate on those issues. So again, the committee should have some confidence that, think we're very much focused on the protection of the domestic environment and the work that we do here, but crucial to the work that the AFP does is taking the fight offshore, and I think working very closely with those international partners, and we've got some great relationships.
I think I'd probably just add to that a little bit, maybe drier than a nice extradition back to Australia or the photographs of somebody landing at Sydney Airport. But there is the element of the multilateral system that we do use. So the Financial Action Task Force that we have talked about is the global standard setter. So there's roughly, I always get this wrong, the team will be mad at me, but roughly close to 40 countries that sets those rules. And then you actually assess countries against those. So they're not just rules that sit there. There's a system where we all go around and assess the global system, whether it's through the regional bodies like the APG or through the FATF. So slightly slower grind because it is through the multilateral system, but you can identify when countries come up short and say, look, here's a secrecy jurisdiction, or this country is actually now a major threat to the global financial system. It's a major vector for these issues. A swift grey listing by the FATF can actually draw a lot of attention and get them to do domestic reforms. So that's just another pressure mechanism outside the day-to-day law enforcement action.
Thank you for that. Just in terms of incentives in terms of recruitment for people within law enforcement, we had evidence from and representatives from a number of universities with new courses being developed. The Australian University here, what Griffin does there. Is there a close collaboration between law enforcement and universities in terms of whether it's through Border Force or whether it's through AUSTRAC as to the sort of courses that are helpful for the agencies to be able to recruit university graduates from?
For AUSTRAC, it's a mixed story. So for financial intelligence analysts, we find easy to recruit our numbers. The tertiary studies around criminal justice, financial intelligence, even money laundering through agencies and universities such as Charles Sturt, Griffith and so forth are invaluable. So there's a good pool of people. And we also accredit many of our own courses through those universities. On the regulatory side, it's much harder because those people are also in demand by the banks and now the emerging Tranche 2 sectors. So finding AML, CTF specialists who are compliance or enforcement skilled is becoming difficult, and we are working very hard to fill the gap that we have at present. I think on the intelligence side too, it's useful that we're part of the national intelligence community and part of the law enforcement space. So there's a natural career progression across multiple agencies for analysts. So it doesn't really matter if they start at AUSTRAC or at ASD or at AFP. They will eventually move through the community, gaining different experiences and promotions, and find their way back. And I think that's a really positive. So it's the one APS, many careers for law enforcement and the regulatory side. I think it comes much more difficult when staff are more frontline responders. And I'll leave that to others to talk about.
I think you've answered it well, Charles.
Certainly on the Border Force perspective, just adding to what AUSTRAC colleagues were just saying, Charles Sturt University for us, very much specifically around customs trade and trade-based money laundering. It gives us a tradecraft experience of people being able to study through to their Masters of Customs Administrations and then being able to filter across to the intelligence aspects as well. So we have got a very good collaboration with Charles Sturt, but to go to the point of my AUSTRAC colleagues as well, the collaboration that is amongst, especially within our portfolio and portfolio agencies, of that joint sharing of intelligence capability and that migration between agencies is certainly coming to effect.
I think it's it's obviously attraction of skill sets, but I think what the US does very well from a law enforcement perspective is their partnership approach with the universities on problem solving. So they'll partner with in terms of some of the big wicked problems that they have, they'll partner with some of those academic institutions to work cooperatively in terms of some of those challenges. We've done it, I think, a little bit through, we've worked very closely with Monash on AI. But again, I note the Commissioner's focus on technology, that strategic engagement and how we work with, not just in terms of recruiting people, but we work with academia in terms of some of the real problems that we have. I think that's going to be incredibly important moving forward. And there is I've got to say, and using Monash as an example, and they do some fantastic work on AI, there's a real willingness from universities to work with law enforcement on these issues.
Yeah, that certainly came across in their evidence and response to questioning, which is fabulous to see that happening. But Mr. Rapicoli, you have some further questions?
Just a couple. Just around the recruitment issues and things like that. With you guys, it's great that you guys all share and people move around and all that sort of thing. That's really good. But how do you convince more people to come into the system rather than staying in the private system? What are you guys doing to entice more to come into what you guys are doing rather than that private sector?
I think, not by money, I don't think. I think it's fair to say. We all of us here could go and work in the private sector and earn more money. I think we got in. I think it gets back to that purpose in terms of serving the community, and I think that is a driver for some people. We get with high level skill sets that come from the private sector into the agency. I think we give them an environment where they're challenged, and I think they're working. Particularly at the minute, there's some real challenges in terms of these issues around cryptocurrency. Some of the work we're doing, some of the technical expertise we've got in the AFP in relation to cryptocurrency, it's world leading, and we're presenting those people with a professional work environment, with a challenging work environment for them to operate in. But there's also recognition too. I've been in this law enforcement agency for 35 years. That's not going to be the norm moving forward. So it's not just the recruitment, it's the understanding we will allow these people to come in for a beneficial period, but the understanding that they're not going to stay forever. And in some respects, we probably don't want to keep them forever. It's how we design our workforce planning strategies to move more people through the organisation. I think we've done some work on that. We'll continue to do it.
This is going to be a different question. But the criminals are experts in these fields sometimes and do really, really advanced work. Are we working with anyone that we've put behind bars and prosecuted? Are we actually using some of their skill sets for better? Like what was the movie with Leonardo DiCaprio? Catch Me, is it?
Catch Me If You Can?
Yeah, like that. Are we doing anything like that, or is there anything like that happening from our partners overseas that we can mirror off and use as well?
Well, I think there's been work that's been done, particularly in relation to cybercrime and hacking, and I think some of the agencies, both overseas, we haven't employed people that. We haven't employed criminals into the organisation, but I think it gets back to intelligence-led police, and we obviously, it's receiving information, intelligence off these people, and how we utilise that information. So I'm not too sure whether Austrac's recruited any criminals, John.
No.
I didn't want to say recruiting criminals. Like, they've done their time and they've got a skill set that can be perfectly used to help, rather than what they've done in the past, which is hinder.
Yeah, well, they've provided assistance, but it doesn't mean they have to get to join the organisation. There's arrangements we can put in place, and I think in answering your question, we're very open to utilising those skill sets.
Yeah. When the Tranche 2 entities come on board, I look forward to bringing those into the Fintel Alliance. I'm not suggesting they have any criminal labelling on their professions, but I think they will bring to us insights and knowledge of how corporate structures, legal structures, how commercial workflows occur that will be invaluable for detecting criminal activity. And I think Fintel Alliance is perfect to start that, because in addition to the work we do in the FIU and the regulator, because it's about being innovative in how you extract and use knowledge.
Thank you. Thank you, Chair.
That's a very political answer, I thought. But very good. Thank you for that. I have a question relating to the Victorian Legal Services Board and Commission for AUSTRAC. That evidence was given to us that information that is currently shared with state regulatory bodies such as themselves, which regulates the legal profession in Victoria, would formalise information sharing arrangements between your organisations and those like the Vic Legal Services Board. Harden the criminal environment for money laundering and financial crime. And I was wondering if you could explain to us what the barriers are to overcome so that we can ensure prosecutions take place, because what they said is that they, are often given information and they're caught in this catch-22 situation, have the information, but they're not allowed to use it to be able to go forward and prosecute. And then I will have a final question about trusts, funds.
I'm a financial intelligence specialist, not a regulatory specialist, so I would have to take that question away and find you an expert response.
That would be good. Thank you. Take that on notice. Trust funds. We've now got the umbrella over real estate agents and accountants. What are the major concerns for law enforcement and for yourselves in Austrac with trust funds being set up? And also, I think there's issues with lawyers' trust funds that are set up and whether they are currently being used to launder money or have money put into their accounts to avoid bankruptcy and people paying their debts. Is that something that's on your radar as well?
So the National Risk Assessment was quite clear on this. So opaque legal structures to conceal identity and activity are problematic. It obscures the ultimate beneficial owners. It uses corporate entities and assets and financial structures so that we can't track workflows and illicit money flows. And those professional services, including trusts, to establish those professional experts who help develop, establish and operate those structures will be captured in Tranche 2, we hope, again, through that transfer of knowledge to understand it more. So yes, it's a very real obstacle to building clear, actionable financial intelligence.
You have any further questions?
I'm done, Chair.
My final question is, where do we go from here once we bear down Tranche 2 and we still haven't, you've got your opportunity for the committee, we're listening of what else, where to from here, what's the next step in particularly attacking this scourge of money laundering?
I think from Austrac, we have great belief in expanding the public-private partnership approach. There are thousands and thousands of Tranche 1 and 2 specialists working on money laundering, terrorism financing and proliferation financing. So we need to harness that human capital and expertise and their systems and their reporting in a more creative way. Gone are the days of an SMR being reported to Austrac, and when we investigate the entities, we create an intelligence report and give it to a law enforcement partner. There are 500,000 SMRs a year flown into Austrac. There's not enough human hands in all our agencies to touch each one of them in that manner. So new techniques like charting and graphing, where data is overlaid with third-party data and criminal intelligence holdings and other information to find the hotspots and nodes where we get best return on investment for both disruption and prevention, is here. Artificial intelligence will be a game changer for intelligence. It will fundamentally change tradecraft and how we do our business. And I think it's a very exciting time as we start seeing the increased reporting coming from Tranche 2, as we see the new capabilities in law enforcement and policing agencies, as we see increased legislative frameworks around scam reporting, money laundering, tax evasion, and start seeing those glued together. I think by osmosis it's going to be a really exciting period for us.
Thank you. Anything from the ASP?
I think John's described it really well. I think we appreciate the support we get from this committee. I think Tranche 2 is incredibly important. Some of the legislative reform that's been supported, but I think across all agencies represented here, we get to appear, but we've got some really smart young people in each of our respective agencies that are, I think, up for the challenge, and it's only going to get more challenging moving forward, Chair.
That's a real challenge, I think, that the criminals, everything moves so quickly, they're getting smarter, they have access to a lot more money than what the good guys do.
There's always hope, Senator. We're on the side of the angels, so there's always hope.
That's the attitude.
Border Force?
So I think for us, we'll be looking at the broader transnational serious organised crime space. So obviously it goes to money laundering, but putting the ACIC on a good footing with basically brand new legislation to allow them to do their intelligence job, which will feed into people at this table. The second one there is the electronic surveillance reform that I've already mentioned, so making sure they've got the powers to go after the communications and manage those aspects for those agencies. I think outside of that, it'll be what are the new emerging threats, what are the displacements. So we've got Tranche 2 done. Some would say late, but the important thing is that we got it done. So we'll be looking at those new emerging threats, and then I think for us, particularly as Home Affairs as a department, it's looking at what we can bring to bear across the system. So it won't always necessarily be legislation. It may be better coordination, better strategy, different use of the resources. How do we measure the harms? How do we direct resources in that fashion and advise the Minister on that? So it won't necessarily be ledge, but it could be.
I agree with colleagues at the table as well. I think Tranche 2 really gave us that valuable insight to what the art of the possible is, and certainly from our perspective, looking at the trade lanes and 71 ports around Australia, that's $1.2 billion worth of trade that crosses our border daily. The expertise that sits in tradecraft of organised crime of understanding how money can be hidden within those pathways, and our ability to be able to surface that and take action against it has been really promising over the last 12 months, and we can see that continuing as we evolve. So very, very supportive.
Well, can I, on behalf of the committee, just thank you all for your submission, for appearing before us today, but even more importantly for the work that you do every day. And yes, we were probably 10 years lagging behind where we should be with this legislation, but we are here. And I'm looking forward to seeing whether or not we need a Tranche 3 going forward. So I'm looking forward to the next round of estimates in the new year to hear more about this, but that concludes our hearing for today. So again, thank you to you, the witnesses, to Hansard, and also very importantly our Secretariat, and to my colleagues that have made time to be here. It's a very important issue, so thank you all very much, and we now stand adjourned.